My lord, right is supposed to mention one matter, my lord. The adjourned motion, my lord. Lord, sir, it is supposed to appear on 4th November, this November, my lord. It is a pension matter. Lord, sir, directed to the headmaster and the DRPC settle the issue of pension of the petitioner expeditiously. The matter is been settled. As soon as that, the matter to appear on 4th November. It's not appearing.
4th November has long gone.
Sir,
So you have not mentioned it on time. Now do not mention.
Lady, I am seeking your ladyship's kind leave to mention this matter.
I have already mentioned the matter.
Yes.
This is a transfer application, my lord. A lady is suffering from
I do not want to know what is the matter about. What do you want?
Lord, any day may be fixed for hearing.
It is impossible. No mentioning.
One correction, my lord.
Correction give.
Any day, my lady.
No, sorry.
The lady is suffering.
To mention transfer matter, my lord.
Is it there in the list?
Monthly list is there.
It is there in the monthly list. You have not handed over the number.
No.
There are so many numbers mentioned. Wait till the next Monday.
My lord, transfer. She's suffering a lot, my lord, due to changing determination. It was in the list. It has been.
You are seeing I have given numbers. It will be taken up. Then let this week go. Following week we'll do.
It's not listed, my lord.
It's not listed, then don't mention. Why did you
Changing-
mention on the day when all matters were accepted?
No, it was, my lord, another bench. It was.
Then it cannot be helped. Sorry, sir.
Or may I come back after?
Next Monday.
My lord, for enlistment in under the heading motion, my lord, it was directed to appear today, my lord, but not today.
Yes.
The order of Honorable Justice Bhattacharya.
No, but then please wait. I'm not accepting any mentioning today. Last week and the week before, all have been accepted. So please excuse. Please wait. Yes.
I permitted to mention only, yes, day before yesterday, an interview list published by the Central School Service Commission. Although there is a specific judgment of the Supreme Court that no tainted candidate is allowed in the sitting in the examination. But the interview list, there are several tainted candidates is there, my lord. And not only that, my lord, the secondary teacher, my lord, they got benefit of the experience marks in the higher secondary level, my lord. There are other.
That is the challenge in the rule
Yes,
also.
Yeah, and there are other anomalies also. The primary teacher, my lord, they got benefit. The health department worker, they got benefit of the experience number, my lord. There are several anomalies, my lord. I indicate.
But even the teachers, the health workers.
Yes. And not only that, my lord, whose date of birth is 1997, it is quite impossible to get 10 marks, my lord. They in experience, they got 10 marks in experience, my lord. There are several anomalies, my lord. I indicate each and every anomaly, whichever I got it, my lord. Relatively kind enough, my lord. Fixed it because from 18, my lord, there is a interview will start, my lord. It will be kind enough, my lord, any day.
18th is tomorrow.
Yes, my lord. Yes, sir. Yes.
18th is tomorrow. Yes.
So, my lord, any day.
Wednesday it will appear.
Oh,
Serve notice.
Yes, I will serve notice, my lord.
No, this matter was initially assigned to Justice Rai Chattopadhyay since regular bench released this matter. Now, since Mr. Chattopadhyay is not sitting regularly, it was released, my lord. Your lordship has the regular determination, my lord. It's a very urgent matter. If your lordship.
What is the urgency?
My lord, the lady teacher, my lord, she was debarred from attending the classes. Ultimately, he obtained an order of transfer. The school authority given did not, my lord, issue, my lord, no objection certificate. That's why several litigation is pending. In the meantime, 5 years has already been elapsed. Now, petitioner has been treated as deemed resignation since he could not join.
And the writ petition is pending.
Yes, this writ petition is pending. I have got an appeal, but the appeal court could not proceed since the writ petition is pending.
Yes.
So, kindly take up this matter in any day.
Then it, I do not know. It cannot be accommodated now. There are so many matters right now. You have to wait. Sorry.
Let it any day,
Please.
My lord,
No.
my lord, may I be
No. Yeah, next week, please come.
My lord, may I be permitted to mention before your lordship? Matter has been fixed on 24th by the earlier bench. Matter is the
24th of
this month.
yes.
My lord, yes, we are the job loser. In accordance of Supreme Court law, we are entitled to resume our duty in earlier positions. We made a representation, but there is no outcome. So we compelled to file the writ petition. It is pending prior to vacation. It is fixed by the earlier bench on 24th. My lord, seeking your just direction to it will be appear on 24th. My lord.
Today is 17th only.
My lord, it will be take time to come back here. That's why I am just
That is?
File already sent down to the department. It will take time to get back here.
All right, give the number.
Yes, my lord.
24th.
Yes. Grateful God.
I have to mention a matter, my lord.
So for increment, petitioner is losing increment month by month.
No, don't mention for inclusion, please.
Inclusion, my lord.
Do not mention for inclusion. Correction give. What is the error?
Howrah instead of district inspector of Purwahat. In another matter, my lord, probably my lord, I have given a order, usual order passed by the coordinator. But the wrong order has been, my lord, but that is not my case at all.
All right, give.
My lord, the matter is on the interest and gratuity.
Do not give any slip for
Madam,
replacement.
And I'm praying for leave to file one matter, madam, and move it urgently. Verification date is fixed on 18th. Regarding SLS second SLSC 2025. What happened, madam? The petitioner is a part-time teacher. When the petitioner went to the commission to ask whether he will get experience marks or not, it was clearly stated that part-time teachers are not entitled to get any experience mark. But day before yesterday, a list was published by the commission, and name of the person was published who will be called for verification. And in the list, the petitioner could find out his colleagues who are part-time teachers, but petition has been deprived.
All right, give. Wednesday it will appear.
Have you permit to mention for first time inclusion of a contempt application, Your Lordship?
Next week come.
My lord, may I permit to mention?
Running in the monthly list as 9:48.
Yes, let it remain. Do not give the number. Yes, sir. Do not give the number next week. Yes. No, not this week. No inclusions. No inclusions.
Interest on gratuity, it is included in the list, but it included in the another heading.
Let it remain. Yes.
News, I have 5, but the wrong.
Next week.
News.
All new motion next week. Yes. No. Next.
May I be permitted?
Say, I know, my lord, that my lord has told us not to mention, but this hearing matter of a librarian for higher scale of 2019, my lord, it has been remanded back by the honorable division bench once. My lord, if possible, my lord, kindly.
Not possible.
For inclusion.
No inclusions.
I seek your lordship's leave to move this matter on an urgent basis, my lord. This relates to the SLST 2025. The petitioner here claims that there are incorrect questions which are out of syllabus.
But then all these things ought to have come earlier, isn't it? Now, when the result is published, you come and say they were wrong answers.
Because my lord, we had expected that they would take remedial measures, but
What steps did you take? Anyway, Wednesday it will appear. Please serve.
May I permitted to mention, my lord?
For what?
Matter relating to compensate appointment, my lord. Father has died. Mother is suffering from blood cancer.
Where is the matter? Where is the matter?
Matter released by the Honorable Justice Bivas Portanayak, my lord.
Released?
Yes, my lord.
Why?
Due to determination, my lord.
When was it filed? Do not know. Come back next week. Yes, call the list, please.
My lord, may I just mention one matter, my lord, for inclusion, my lord, pending since 2023. But urgency is, my lord, the petitioner is.
Next week. Next week.
May I have your lordship's kind leave to mention an urgent motion which was directed to appear today, your lordship, by his lordship Sogata Bhattacharya. This
Please come next week. Call the list, please.
My lord, Advocate Dilip Kumar was appearing for the petitioner. He is unable to appear due to some personal difficulty.
Previously also they have took time. This is the matter. I have only for this matter I have come to this court. Otherwise I could have appeared virtually. Beforehand they did not inform.
He instructed you yesterday at night.
Instructed you yesterday? Yes.
My lord, he instructed.
What is so very important that you are required to come?
No, my lord, your lordship wants physical appearance.
Whose?
Normally advocates.
No. You can join virtually also.
And some documents I have to show before.
Then that is different.
I am giving copy to them so that they subsequently do not come and say that we do.
32 and 33 Ismail Street, there is a problem.
Yes, but 32 do not exist and 33 is a vacant land.
And he says unauthorized construction going on.
He has he has incorporated photographs of 2013. This petitioner did not make the any private respondent party in the writ application. Number the petitioner induced this honorable court to pass an order on a situation which do not exist. Well, I am keeping 2 copies to letter of ticker controller, which shows that and 1 copy of the IB inspection book. That
There is already a report of the executive engineer.
yes, my lord.
You are giving in addition to all those.
Yes, my lord, we have got it subsequently because we
All
have to
right.
collect from the assessment department.
All right.
I am giving copy.
Let me see the copy
yes,
what you
yes.
are handing over. Ashunta, adjournment has been sought for on behalf of the learned advocate representing the petition.
Tomorrow, man.
Day after tomorrow, can it be possible?
Then next Monday.
Learned advocate representing the Kolkata Municipal Corporation relies on the communication forwarded by the Deputy Thika Controller, Kolkata, dated 3rd March 2025, along with the photocopy of the inspection book relating to the property at 33 Ismail Street.
But 32 we do not have because there is no premises as 32. That has been bifurcated 40 years back by H/1, H/2, 32.
Stop. Copy of the same has been handed over to the learned advocate representing the petitioner. Stop. Submission of the learned advocate for the corporation is that the petitioner induced the court to pass an order on a situation which does not exist at all. Stop. Premises, there is no document with regard to premises number 32 Ismail Street. And the premises number.
Existence of premises 32.
There is no existence.
At presently, premises 32.
Document बोलना तो आगेटा. There is no premises. There is no existence of premises number 32 Ismail Street. And as regards 33 Ismail Street, the same is a vacant land.
Vacant.
Stop.
And Thika controller already it vested. Thika controller
is a vacant land, and the question of unauthorized construction is absolutely false and misleading. Released next Monday.
Next Monday. I'm grateful to your lordship.
Email I am for the petition amount. Petition amount.
What happened to your glasses?
It's broken, my lord.
It's broken.
Very bad.
So you want adjournment?
They had to start, my lord. They had to start. My petition for contempt, my lord, it was the KMC has already filed a report regarding this that the illegal construction has been committed by the.
All right. Yes.
There are 2 contempt applications, one at our instance, one at my learned friend's instance. Milord, at a belated stage, my learned senior friend, Milord, informed the Honorable Court that, Milord, they have invoked the emergency provision of the Kolkata Municipal Corporation. Whereas, Milord, there was a prior direction, Milord, of your lordship, when my lord was taking, Milord, Group 5 matters, Milord, to serve us, Milord, demolition sketch map, infringement statement and all. When, Milord, we filed a contempt application saying that, Milord, this has not happened, Milord, we filed a writ petition saying that they have come, Milord, without serving those documents, they have come to demolish. Milord, an order was passed by my Lord Justice Aniruddha Rai, Milord, staying their hands because, Milord, those directions of your lordships are not complied with. Then only, Milord, the corporation informed my Lord's court that, Milord, they have invoked the emergency provision. Milord, the documents are Milord little suspicious in nature because Milord in the documents, Milord, where they are indicating the provision of law, that is Milord whitened. Milord, whitener has been used Milord in those particular Milord portions of Milord the report submitted. And Milord, my Lord's order was passed Milord months back. Milord, no occasion arose then, Milord, to invoke emergency provision. Milord, when the time came for them to answer to the rule of, not to the rule of contempt, to the contempt petition, then, Milord, they woke up from their slumber and say that, Milord, this is dangerous and they are invoking, Milord, emergency provision. So, Milord, our writ petition is against, Milord, that invocation of emergency provision because that cannot be, we say, Milord, mechanically invoked. Milord, my learned friend's contempt application is against, Milord, not demolishing. Milord, our contempt application is against Milord this
Did you
emergency.
file any writ petition
Yes, our writ
also
petition.
challenging
Yes,
that?
yes.
What
And Milord, there Milord an interim order is there Milord till last day of January 2026.
all right.
And Milord, my Lord's desire was that Milord all these matters
We heard
be taken up
together.
together. Milord, there are two writs, possibly two contempts.
One writ,
One writ and two contempts.
Hmm. So,
My Lord is desirous to take up the matter.
but then how can the contempt be taken up because your writ is pending?
But the MAD has jurisdiction. MAD has taken it.
No, no,
It is already appealed.
jurisdiction কথা জজ সাহেব বলছেন না. Yes, Milord, the writ petition is to be decided. If he
Yes.
succeed in the writ petition,
Right.
he loses in the contempt application.
So,
That's true.
let it be adjourned for the time being.
Very well. Milord, the interim order is there till
Yes,
last day of
we were already enjoying interim order.
You can fix his Milord problem of the
Petition is
spectacles.
already appearing in the list today.
Eh?
True.
Lead petition is already
Everything
appearing
is
in
there.
the list.
Everything is there in the list.
There is a separate writ also.
No. This writ petition.
That is appearing in
On
the
the
Same issue, your lordship directed the personal order, and my lord, I reported to your lordship, my lord, when your lordship passes an order, which my lord is complaining of a violation he has filed, that immediate after that, this action was taken because of the nature of the construction, 408 my lord action. Then my lord passes an order. Your lordship used to pass such an order, certain orders, my lord, in the contempt application of the complainant. Now, my lord, when your lordship is in process, my lord, regarding the implementation of that order or to see, then he moved a writ application regarding that because
No.
he was submitting, my lord, that I have not been informed or something like that. Notice was not given to me. That was also clarified in the contempt petition that when the invocation of 408 is there, there is no scope to give any notice to either of the parties. Therefore, my lord, then he moved a writ application. On that writ application, the court, my lord, the initially entertained and with the direction to ask my lord to submit a report. We gave a detailed report of the entire situation. Now, my lord, that application which he moved, then the court said that since there is a contempt petition, therefore they have some connection on the same premises. Honorable Chief Justice was pleased to my lord assign the writ petition also.
Oh, the writ is also here.
Yes.
Therefore, my submission because my
345.
submission, whatever the contempt is there, both the parties respectively filed, with reference to an earlier order, that is to be looked into. But initially, when he filed the writ petition, he should decide whether 408 he can succeed the 408 action in that case. Therefore, writ petition, you should take it up long pending.
Yes.
For a long
Let me see the writ.
You should start deciding the issue.
Wait.
This will be 786.
No, my lord, 345. 5 is
345 are the serial numbers.
serial numbers. Yes.
786.
786. WPO 786.
Yes, 786 impugn notice.
My lord will kindly take, Milord, there is a comprehensive affidavit filed by us in the contempt application, Milord CC 42. If my lord kindly takes that, Milord, that contains all the documents. Will be, Milord, easier for your lordship. Yes, Milord, this one.
Yes.
Yes. My lord will kindly have a look at, Milord, page 32 first, which was, Milord, the first complaint in point of time by my learned friend.
14921.
Yes, Milord, yes. This is, Milord, with regard to premises number 3. And, Milord, the author of the complaint is Mr. Abhishek Misra at page 33. I believe my learned friend's client is Mr. Abhishek Misra. This is to inform you that one sham projects, Milord, I am...
You are sham.
Yes, Milord, I am sham.
All right.
Sham Projects is the promoter and developer of premises number such and such. Under the veil of the said company, actually Shajjan Saraf and Ravish Sharaf, both are of such and such, are acting as directors of the company. As per the sanctioned building plan, basement and ground floor of the said premises were meant for car parking. So, my lord, one thing is admitted that there was a sanction plan. So, it's a case of deviation from the sanction plan. Very recently, I have noticed, should have been noticed, that the aforesaid Sajjan Saraf and Ravi Sharaf are wrongfully and illegally converting the said basement and car parking into commercial shops without obtaining sanction from the municipal corporation. So, my lord, it's a complaint of change of user. It is well settled principle and declared by the Honorable High Court, etc. Then, my lord, very recently it has come to my knowledge that Sajjan and Ravish has already cast RCC slabs basement and converted slope of basement at par with the ground floor. Further, they have constructed brick walls for demarcating for the commercial shops within the basement. They have similarly taken steps for converting the said ground floor from the sanctioned car parking area thereat in a commercial shop. Then, next paragraph, those illegal activities are in violation of 416. Thus, by my letter dated such and such, with my letter dated such and such, I have earnestly requested your good self in this premises. You are once again requested. So, my lord, the complaint was already, my lord, with regard to, my lord, change of user in the basement and ground floor. That was all, my lord, that was complained of in the complaint. My lord, this complaint was followed by another complaint, or my lord, rather a reminder at page 42. My lord, this was at a point of time when, my lord, anybody was yet to come to court.
Yes.
Yes, my lord, this is 12 January 2022.
Same thing.
Yes. Subject to, my lord, of course, correction by my learned friend, same thing. Then, my lord, there was one more complaint, my lord, 24th January 2022, that is at page 40. Not, my lord, chronologically added. 42 is prior, 40 is, my lord, after that.
All right.
My lord, after that, my lord, since nothing had happened according to my learned friend, my lord, writ petition he had filed, my lord, the private respondent, where, my lord, a report was submitted. Kindly, my lord, have a look at the report at, my lord, page 50.
Yes.
Yes. My lord, the report is, my lord, here referred to. This is my lord's order, possibly, my lord. Yes, my lord's order. The petitioner alleges illegal and unauthorized construction by the private respondents. Advocate representing Kolkata Municipal Corporation has produced report before this court. The said report mentions that the Kolkata Municipal Corporation issued a building sanction plan with a such and such under rule such and such for B plus G plus V storied residential building. Subsequently regularized under rule such and such. After receiving telephonic complaint, my lord, my learned friend was alleging that written complaints were lodged, but KMC stand was, my lord, they had received, my lord, a telephonic complaint. Inspected the site, found some deviations from, my lord, the sanction plan. Building department serves stop work notice along with police intimation slip to local police station. All present works are lying suspended. A copy of the report has been handed over to the advocate representing petitioner and private respondent. Statement of the report, it appears that KMC has already taken steps. Accordingly, no further order is required to be passed and writ petition is disposed of. Report is kept on record. Then, my lord, a 401 notice, my lord, which was referred to, my lord, in my lord's order, my lord, that had been served, my lord, which my lord will kindly find at page 52.
Yes.
Kindly see, my lord, the nature of deviation, my lord, indicated in the first notice at page 52. It says the same is being carried on, and, my lord, that according to the tick marks, and says in deviation is not without sanction nor, my lord, in violation of the conditions of sanction. It says in deviation from the sanctioned or approval plan or my lord, or in violation of the conditions of sanction. Then, my lord, there was a complaint which was also referred to, my lord, in my lord's order, that, my lord, KMC on the same date, my lord, wrote a letter to the police. That letter is, my lord, at page 53. My lord, this stop work notice and the letter to the, my lord, police were off on the same date. With reference to above, this is to inform you that notice has been under section 401.
Yes,
has
the
been
next page.
53, my lord.
Yes,
My lord,
53 I've read. Yes.
very well. Then, my lord, the site inspection report at page 54. Site has been inspected. This is what was, my lord, referred to in my lord's order also.
Yes, yes.
Site has been inspected with some sanction plan.
Yes, next.
Very well. Now, my lord will kindly come to, my lord, page 55. Yes.
The order comes.
Yes. And it says that, my lord, they are satisfied. The court took note of the instruction forwarded, my lord, third paragraph, by the engineers of the corporation signed on such and such, wherein it was recorded after receiving telephonic complaint, department served stop work notice with intimation to local police. Today, when the matter is taken up, report has been forwarded by corporation, appears to be photocopy of the earlier instruction. More than a year has lapsed, but the corporation has
Yes,
not.
then what happened?
Then, my lord, the next order is, my lord's order is at page 57.
Yes, inspection conducted.
Yes, conducted demolition sketch map has been prepared with infringement statement. My lord, the moment, my lord, may I stop here for a moment? My lord, the moment this submission is made, my lord, this invocation of emergency provision that goes. And the demolition sketch map has been prepared with infringement statement. Department is contemplating to take steps under suitable subsection, etc. The third paragraph, executive engineer is directed to take immediate steps to deal with the unauthorized construction. Proceedings to deal with the unauthorized construction shall be concluding at the earliest, but positively within a period of 8 weeks from the date of communication of the order. Second paragraph, my lord, there was a direction. Let a copy of the demolition sketch plan and infringement statement be served upon the necessary parties. My lord, that was, my lord, specific direction. My lord, that was not done. My lord, this order is important. That was not done. And my lord, instead, what was done, my lord, they came, my lord, to, my lord, demolish my premises. Which is why, my lord, I initiated a writ proceeding and, my lord, an order was passed at page 66. I'm sorry, my lord, not at 66.
96.
96. I'm thankful to my lord. 96. Kindly, my lord, have a look at the order passed by your lordship. The date of the order, my lord, I just indicate the date. My lord, the date was 17th October 2023. And then, my lord, this is an order of 14th August 2024. My lord, this was taken up by my lord Justice Aniruddha Rai. Kindly, my lord, turn to page 98. Referring to an order of the Honorable Bench of 18th October 2023, my lord, the last order passed by your lordship. Annexure P13, Mr. Mojumdar submits that pursuant to the direction made therein, first notice of demolition, annexure, etc., was issued upon the jurisdictional police authority seeking assistance. The petitioner, by their later dated such and such, have requested the municipal authority to provide the demolition sketch plan along with infringement statement. My lord, the date of the letter was, my lord, 8 December 2023. The same have not yet been provided to the petitioners, though there was a specific direction on 18th October 2023 for the same. Defying the said direction of the Honorable Coordinate Bench, the demolition notice was issued. Lastly, the municipal authority issued the said notice on 12th August 2024. Milord, I pause here for a moment. Had there been any emergency, Milord, since September or October 2023 till Milord August 2024, they would not have waited. So, Milord, this defies their logic that, Milord, there was a necessity, Milord, to invoke emergency provision. Seeking assistance from the local police authority on August 14, 2024 to carry out demolition. Then, Milord, Mr. Ghosh's submission, kindly, Milord, just have a look at in the same page. Mr. Ghosh, Learned Counsel appearing for the Municipal Corporation, submits that the entire demolition process was initiated by KMC in respect of the said premises. Further steps were taken to deal with the unauthorized construction and to complete the demolition process. He submits that he has to take instruction from his client whether copy of demolition sketch map and infringement statement have been served upon the petitioner or not. Till such time, Milord, there was no indication that Milord KMC is going to take Milord an emergency provision. At this stage, he is also required to take instruction from his client whether due notices were issued. Mr. Ghosh further submits that the petitioner had previous opportunities to challenge the demolition. Milord, I am not troubling your lordship. Kindly, Milord, then come to the ordering portion at Milord page 101. Last two paragraphs, Milord. Accordingly, there shall be an order of injunction, Milord, staying their hands. And Milord, the respondent number 4 is directed to file a report. Then, Milord, comes the report.
103.
Milord, 103, Milord, is the report. And in this report, Milord, for the first time, Milord, my learned friend, senior friend's client, Milord, informed the Honorable Court that they have contemplated to invoke emergency provision at page 108. Rather, Milord, at Milord, at page 108, the second paragraph. Instead, they say, Milord, instead of subsection 1 of section 400, they are, Milord, following subsection 8 of section 400. And see, Milord, kindly see after how many days. My lord, if there is a dangerous building which is likely to cause, my lord, death of, my lord, human lives, then, my lord, they would have immediately invoked that. Whereas, my lord, specific statement before my lord's court was that, my lord, demolition sketch map has been prepared, infringement statement has been made.
Where are the infringements? Show me, please.
Yes, my lord, kindly come to the report, my lord. After that, there are some documents annexed to the report, page 110. Kindly see, my lord, the third line, the fourth line rather, at page 110. These were annexed, my lord, to the report. Some deviation are found. The person responsible has covered the ramp entrance, my lord, this is with regard to the basement, by brickwork and slab and made a shop but did not construct the ramp. The person responsible also installed I said, by supporting iron joist or pipe at the roof. My lord, today so far as ground floor and basement is concerned, my lord, we have regularized that. There is, my lord, no complaint with regard to that anymore. My lord will kindly inquire from my learned friend on both the sides.
Regularized means?
Means, my lord, we have demolished that. My lord,
What thing? This ramp and whatever.
yes,
you
yes. My lord, those
constructed?
were for garage purpose. My lord, the allegation was we are converting that, my lord, for shop. My lord, we have stopped doing that. These are garages.
Right now it is for carpeting
Yes,
space.
yes, yes.
So
yes.
you say the deviation which was found is
Now, my lord, they are on the roof.
Roof you've constructed
CI shed. Yes, joist pipe. You know, that's the allegation came for the first time.
All right.
My lord, the complaints my lords have seen, my lord, were only with regard to basement and my lord, ground floor.
Hmm.
Before my lord's court, when the matter was being taken up, my lord, the matter was confined to that only. My lord's order was passed also.
Very well. Now they have found something
Yes,
else.
yes, yes. Now, my lord, kindly come to page 112. This is, my lord, the police complaint. Same thing. Kindly come to 113.
Yes.
Regarding premises number 3 Digambar Road, proposal for initiating under section 400. Does not say, my lord, 408. Then, upon, my lord, inspection revealed that person responsible has covering ramp entrance below. These are with regard to the basement. Then, my lord, CIS temporary structure at roof. All are deviation from sanction plan.
Are you willing to remove this CI shed?
My lord, I am entitled to a hearing.
Are you willing to remove?
That, my lord, I need to take instruction. But, my lord, I am entitled to, my lord, the demolition sketch map. I am entitled, my lord, to a copy.
Demolition sketch has been given.
My lord, demolition sketch map subject to correction is not given. And what is, my lord, important is page 114, where, my lord, I indicated that, my lord, they have whitened the provision. Which have, my lord,
114.
yes, 114, my lord.
Yes, which portion?
Kindly see, my lord, the second line at the top.
400 and then
After 400, my lord will not get the subsection. That is whitened. Erased. And the same thing has happened, my lord, in the last line also of the same page. Subsection is erased.
114. Sure.
This, my lord, creates a suspicion.
All right.
Now, my lord, kindly take page 115.
Yes.
My lord, this is their infringement statement.
Mm.
My lord will see for car parking, my lord, now there is no infringement. Then comes, my lord, structural stability. They say unknown. My lord, when I, my lord, invoke emergency provision, I must be certain that, my lord, this is so dangerous and the stability is so dangerous that it may cause, my lord, something, my lord, very fatal. They say it's unknown. So structural stability is not, my lord, conducted. Stability, my lord, inspection is not carried out. Then, my lord, quality of material unknown. So they are not in a position to say that, my lord, this construction is dangerous.
Any final order passed?
No, after, my lord, they say 408, so, my lord, no need to pass any order. There is a direction, my lord, for demolition.
Where is that?
My lord, that is at page 117. Which, my lord, has now been stayed and, my lord, the interim order is continued. So, my lord, the moot point, my lord, subject to, of course, correction by your lordship, to be adjudicated in these proceedings is whether, my lord, they were entitled to invoke, my lord, this.
Right, let me hear the corporation
Yes.
once.
One more allegation is also there appearing at the report filed by the KMC, page number 12, that the whole portion was sanctioned for residential, but they're using it as commercial.
No, right now,
Till such time, my lord, that has not come, that came, my lord, later.
commercial where? In the ground floor?
No, completely. Whole building is used for commercial.
Whole building?
Whole building.
But that came later, my lord, I would take the lordship to that, yes. So, my lord, writ petition started with something, my lord, it has now taken the shape of something else.
Right.
I
Corporation.
didn't get a chance, my lord, to oppose those allegations.
Philosophically see the picture, as my learned friend is petition has stated. The structure, my lord, we have raised.
Page. See, one of the allegations was
I know.
car parking spaces being converted to shop rooms. According to
Car
the
parking
petitioner,
space, my lord, sudden changes took place. Apart from that, the shade, my lord, has been created, covering about 4,000 square feet
at the roof.
at the roof.
Right.
Therefore, my lord, we take steps that is an additional floor.
Right.
An additional floor, my lord, it may create, my lord, a lot of hazard.
Yes.
And the permission is required if it is, because since the permission.
No, I followed that.
My lord.
The ground floor portion,
My lord.
according to the petitioner, the car parking space is there. Are you aware of it?
My lord, certain actions have been taken later on, my lord, during this process, my lord, exactly what is the position, because thereafter stay order is granted. Therefore, we did not proceed further.
Right.
Second, my lord, the structure who has been erected in the top floor.
No, top I'm
No,
coming.
no, so
Top
far as that.
coming. Ground, you are not sure. One, so the other two remain, that is the residential building used for commercial
Absolutely.
purpose and the top.
My lord.
Please conduct a fresh inspection and see that whether the
Your lordship once directed to make a fresh inspection. Sometime about 4-5 months back.
25.
I ordered it at 7 January.
Where is that report?
31st January report of my case.
Let me
And
see.
we submitted a report.
What does it say?
But there's a commercial, completely commercial use, and once we, my lord, the shade was removed, top floor, then they again, my lord, restored it. After that. My lord,
But it was observed from the sanction plan that the ground floor was allotted to use as commercial purpose. So this building issued a letter to CI shed. Ground floor to be used for commercial, you all permitted?
No.
This is mentioned.
Well, there is no permit at page, my lord. Let me see, my lord.
From I remember, my lord, only the ground floor was permitted for commercial. One floor was permitted for commercial, but they've used the entire building for.
All right, ground floor commercial by way of shops or what?
Shops.
Well, I need to take in.
Possibly, my lord, one shop, certain, my lord, the ground floor, possibly, my lord, one shop was, my lord, the permitted, and the other, my lord, for car parking space. My lord, whatever the car parking areas, that was also changed. Certain commercial, my lord, is permissible, apart from the required, my lord, the car parking spaces.
The court is contemplating is,
my lord,
quite some time has passed.
My lord.
You cannot proceed with the demolition because of pendency of
No.
matters.
I started
Contempt.
demolition, and your lordship.
Stay order came.
I said, then, my lord, your lordship also, my lord, the in the first contempt petition, we took steps, my lord, we removed, and on 18th, when they got the stay order, that was the day fixed for, my lord, demolition.
I understand.
And, my lord, when the petition was moved, my lord, with leave, then I had no information or, my lord, recollection that I had already, my lord, submitted to your lordship, then action had already been taken under 408. Therefore, I could not, my lord, it is my fault, I could not report to the
No,
court.
whatever. So now, if you give him an opportunity of hearing and finish off the whole thing.
But your lordship can satisfy him, my lord, what would be the point? Because 408.
I will not go because
No, I submit, my lord. If your lordship, my lord,
408
appreciate, my lord, one thing, my lord, I may submit to your lordship. There is no scope for conversion from 408 to 401. That is the decided judgment of this honorable court.
Absolutely. So why are you wanting a judgment? Because there is no scope for conversion.
Therefore, my lord, giving a hearing indirectly mean, because your lordship, my lord, there is an implication of that, my lord, the decision, if your lordship, my lord, finally decide that whether it could be, my lord, changed to when the action has already been taken as a 408, it could be changed to, my lord, 401, because giving a hearing means, my lord, to take steps according to 401. That is the, my lord, scope. Therefore, two scopes are decided. This court, my lord, has, my lord, considered the division bench also, single bench. Therefore, your lordship kindly take the trouble, my lord, to decide.
Court will not decide.
No, decide, my
Because
lord,
it
the
is a
whether.
decided issue.
No, decide, my lord, is, my lord, the whether the action which has been taken under the 408, right or wrong.
This writ petition is in respect of premises number 3, Digambar Jain Temple Road, ward number 22, Borough 4 of the Kolkata Municipal Corporation. The corporation has already detected unauthorized use and unauthorized construction at the subject premises and has invoked Section 400 within bracket 8 of the KMC Act 1980. Stop. On the day fixed for demolition, comma, the petitioner obtained an order of stay for which the demolition proceeding got stalled. Stop. The proceeding is stalled for more than a year.
No, I mean, sorry, my lord, interrupt you. The demolition order was passed immediately after passing a lordship first order, not after that. On 6th of November. Your lordship only.
Here.
Yeah, I mean 24, my 20th.
That means 1 year has passed.
From that date, that
Yes,
may be
that
right,
is
but
what.
the order was passed, my lord, immediately thereafter.
Maybe. ঠিক আছে. The primary ground for challenge of the demolition order is that no opportunity of hearing was given to the petitioner prior to passing the same.
As directed by this honorable court, my lord.
Step next. The fact that there is no scope for granting any opportunity of prior hearing in invoking section 400 within bracket 8 of the Act, which is an emergent provision, is a settled law. Stop. According to the petitioner, comma, the unauthorized construction of shop rooms by conversion from the car parking spaces
Have been undone.
Stop. The CI shed at the roof, which was initially detected, thereafter removed, and again constructed, is still standing. Stop. The building, which was sanctioned for residential purpose, is being used for commercial use. Stop paragraph. For ends of justice, comma, to put an end to the litigation, comma, the corporation is directed to afford the petitioner an opportunity of hearing at the earliest, but positively within a period of 4 weeks, and pass a reasoned order in the matter. Stop. The private respondent shall also be provided a hearing. যেখানে বললাম না petitioner and the private
What with
respondent
regard to the premises?
and the private respondent.
He stays will a different ward altogether.
He doesn't stay near you. আচ্ছা ঠিক আছে রিট পিটিশনার অবধি রাখুন ওটাকে ছেড়ে দিন ঠিক আছে When is the other matter due to appear? The interim order is still
Last day of January.
last day of
2026.
January. Oh, yes. Release the matter on 6th of January.
Great, great.
May not be given an audience.
Not entitled. In law, he is not entitled.
Let us see what happens later on. Contempt gulo
My lord is keeping below the
return order holo.
contempt applications and all pending.
All
Very good.
6th. All matters will appear on the 6th of January.
Grateful. Grateful. Great.
আরে বাবা ওরা কথা বলছো না কেন আমরা অর্ডার পাচ্ছি না কি জানি কথা বুঝে না কেন
Yes, my lord. My lord, it is for correction, my lord. Year of the case has been wrongly recorded as 2024 instead of 2025.
All right. This is the only thing.
Only.
Okay. All right. Next.
My lord. Next is also correction, my lord. Name of the petitioner is Shuddhadev Chatterjee. It has been recorded as Shraddhadev Chatterjee. I have corrected this. Yes. Corrected order. Great. Great.
But I have taken out an application for addition of party.
I am appearing for the School Service Commission.
Where is the petitioner?
My lord, I appear for the petitioners led by Mr. Bikram Banerjee and Shuri Pradash. My lord, they're just coming, my lord.
Yes.
They are coming, my lord. Just
All right.
for a moment.
Lord, kindly take the last order of your lordship.
10 marks.
Lord, the district inspector of school was directed to take instruction whether they are working in a substantive post or not, since they are the part-time teachers.
Who's there for the state?
I'm for the state. I'm being led by Mr. Bimal Kumar Sai. Probably Mr. Sai is online.
Online? Hearing online. He'll be appearing online. All right, he'll join. Show me the report, please.
He has joined.
The report which I've received from the Murshidabad.
My lord, this
Please give a copy
I
to.
pray before your lordship to adjourn this matter. Tomorrow I will bring the report, my lord.
The report is here. The report is here.
This is the report from who?
How many DIs are there?
Many DIs.
কাউন্ট করেছি
দেখি। One from Murshidabad and the other from Purva Bardhaman?
Yes.
All right. What does it say?
My lord, it says, my lord, it was done purely on a temporary basis.
Orally, he was appointed, my lord. He was the guest petitioners are the guest lecturer. There are no management committee resolution. There was no post. Only due to the benefit of the students on oral basis they were appointed, my lord. And the claim of the petitioner are not maintainable before the court of law, my lord.
So the authorities, you got a copy?
No, my
lord, I'm sorry.
My lord, what is my claim, my lord? I believe they have stated that these are not sanctioned posts.
Take a copy.
No, I am not telling about discussing about here the sanction post, my lord. A guest lecturer or part-time teacher is not eligible to become against his substantive post, my lord.
So according to the authority, you are not working in a substantive post.
My lord, what is substantive post? I believe
It has not been stated substantive post is not synonymous to, my lord, sanctioned post. Substantive post means, my lord, a post which is regular and subject is being taught. My lord, that is why on the last occasion, your lordship member, I beseech your lordship to add West Bengal Council of Higher Secondary Education as a party, and your lordship allowed that prayer, and I am served. My lord, he is the petitioners are in their respective schools are the only teacher teaching that subject in classes 11, 12. And that is what the West Bengal Council of Higher Secondary Education subject recognition is being given, taking the name of the petitioners that they are teaching the subject. You kindly recognize the subject. And on that score, my lord, subject has been recognized. Substantive post and sanctioned post, my lord, are completely different. Substantive post means the post which is regularly utilized and taught. Here, my lord, the subject, whatever may be the subject education is being taught by a part-time teacher in a regular post. That is the meaning of the word substantive, my lord, not
What
sanctioned.
exactly does the advertisement require?
Advertisement.
My lord, please come to the report, second page of the report of the Office of the District Inspector of School, my lord.
report? Which report?
Murshidabad District, DI of Murshidabad. Second page, my lord. Nabipur Saralbala High School.
Yes.
Respected sir, this is for your kind information that Muhammad Samim Sheikh, qualified MA in Education B.Ed, bracket close, son of so and so, my lord. Murshidabad was arranged locally to teach the subject education in 11 and 12 section in the school purely temporary basis on school own fund. He is taking classes for education since so and so, as there was a shortage of government teacher in that subject. The school management committee has orally appointed him based on school own fund in the interest of the student for the sake of the school, my lord. There is no management committee resolution made for this appointment and no official appointment letter
There
issued
is no
to him.
requirement in the rules, my lord, for this. Rules does not say anything. If your lordship kindly comes to the
I mean, the school accepts that the teacher is there for the last 3 years, and the temporary arrangement, how long will it continue? How long can the authority continue? If the petitioner is not there, then the subject will not be taught in the school. You want the students to suffer or what?
My lord, as on date, there is substantive post or not, it is not clear to me. But a guest lecturer or part-time teacher is not entitled to get a benefit of the regularization, my lord.
Who is seeking regularization over here? He is not praying for regularization.
Sure.
That is not the case. That is absolutely not the case of the petitioner. You please wait. I have seen the report. Let the commission reply.
Yes.
Report. Reports copy is not.
Copy.
তোমাদের রিপোর্ট
আমাদের report করে দাও।
তোমরাও তো রিপোর্ট দিয়েছো
There is no
তোমরা আগেই রিপোর্ট দিয়েছো মনে হয়
No, no.
not in this matter.
No, perhaps my learned friend is not correct.
Please.
Show me the advertisement, please.
Yes, advertisement, my lord, at page 130. Advertisement does not specify anything. 68, page 68. Page 68.
Where is the
Nothing,
relevant
nothing has
portion?
been mentioned. Only in the rules.
In the rules?
Rules, my lord, page 140.
140.
Relevant page.
Permanent or contractual?
Or contractual.
Page 140.
Yes.
In a substantive post. substantive post is not defined.
Not defined.
A person is teaching for the last 3 years and the school accepts that had the teacher not been there, there is no other teacher. He is the only one teaching that subject in the school. Will that not be treated as prior teaching experience?
That will not one aspect may I just little bit one is post, one is vacancy. Post, as very correctly fallen from your lordship, it's a substantive post.
Do not go into all these things. Thing is the teaching experience. What is important is whether the person has teaching experience.
One who is not working in a substantive capacity, the DI's instruction I am reading. There are two instructions apparently. One is both are dated 13th or signed on 13th. The name of the petitioners are working. The locally arranged contractual teachers purely on temporary basis under different schools in the district of Purvo Mendipur. That is what Purvo Bardhaman DI is saying. And the other one is Murshidabad. Are engaged purely on temporary basis according to their qualification. So therefore, a person, knowing fully well of the consequences of his engagement, cannot, contend that that engagement whatsoever would inure to his substantive experience as a teacher and would additionally allow him some benefit in a recruitment process. The rule is not under challenge. Locally arranged contractual teachers did not even know
what you are required to know.
Whether these persons, that we have to rely on the DI's report.
The DI is referring to the school's report where actually the teachers are performing.
They might be performing by virtue of a temporary arrangement.
Yes. Admittedly, they admit, and it is mentioned temporary, but it is going on in a permanent manner. From 20 to 3 years, they are on. They are
with all humility, this
whatever. See, this is not the court's requirement to decide. What is to be done is the commission. It is for the commission to decide whether this can be treated as a teaching experience or not. Otherwise, if you say that the rules is not under challenge, then this matter all is
everything is
relating to the rules. Somehow or the other, it touches the rule.
We cannot act contrary to the rules. The rules, if it is very specific, if the rules stare on the face of the petitioners, whatever, I am bound by the rules unless I throw a substantive challenge to the rules. Today, your lordship is looking into a rule. The rule. So therefore, in the absence of a challenge.
That is what his submission is, that you are not challenging the rule, and the rule specifically mentions temporary, not temporary, it's contractual on a substantive post. Then it has to be decided what is a substantive post. The matter will be posted for hearing. Please come.
Only one thing, my lord.
Yes.
Consider. Yesterday, my lord, Saturday, the results have been published without even verification. Some person's contractual teacher who have filled up the application form has been given marks. We have not been given marks because we could not fill up the form.
Those particulars are not
come up with supplementary affidavit if any discrimination is there.
My lord, second, in the absence of any substantive word substantive being defined, and it is on admission that I am teaching in the school, I am the only teacher. The word substantive denotes, my lord, not sanctioned. It denotes that it's not even a vacancy. The post is regular. The term is not vacancy. Term is post. Once, my lord, now, if your lordship, my lord, why I am apprehensive? If the results have been out, I have not been called for verification in absence of this 10 marks. Getting it for hearing, my lord, ultimately the matter will be infructuous.
Ultimately, the Supreme Court is there to decide.
My lord, one way or
whether there is discrimination or not, this much the court can see that if others in the same position as yours have been given the benefit, you have been deprived, then the court can interfere.
The question of
the-
deprivation perhaps would arise not post-verification stage. They are
Post-verification.
We have not yet verified anyone.
How could you give the 10 marks benefit?
Who? We have not given 10 marks benefit to as on at least these petitioners.
Let it be recorded.
10 marks benefit is to these petitioners. We have not. If he comes up with particular that this person has been given a 10 marks benefit as against me.
That is the reason
those particulars are not here.
It was not there because now they have come to learn that there are similarly placed candidates who have got the 10 marks benefit in the interview list. This is the reason. 1 minute. Who are you?
I'm one of the candidates, my lord, untainted candidates. I have taken out an application.
For what?
For addition, my lord.
Why?
I tell you, lord.
Why in
if
his
the
petition?
ineligible candidates are given marks,
Why not come up with a fresh writ petition? Why you want to be added in his petition? If you have an independent grievance or a
my lord,
claim,
the independent grievance, my lord, has not yet been given by the commission. They are asking against the commission to give it. That's we are opposing. Kindly visualize, my lord, commission has not yet given to anybody like them. They are saying they are similarly situated like us. That's not.
how do you know like you or not?
Because the entire petition says, my lord, they are, my lord, entirely appointed by the school. My lord, I just tell you, lordships.
You are also appointed by the school.
Commission, not by the school. I am by the commission.
You are appointed by the commission.
Yes, my lord, the untainted candidates, those who are getting the marks. Now,
I did not follow.
my lord, I tell you, lordships. Persons who will be getting teaching experience, those who have worked in a government aided in a substantive post. That presumes or presupposes that the appointment has been given by the appointing authority. Appointing authorities are now the board, and the commission is the recommending authority. So whatever period I worked on the basis of the recommendation of the commission, appointed by the board. So I am eligible.
So you are eligible, you will get the
Suppose
marks.
if some ineligible persons gets the marks, then makes the zone of the consideration narrower.
Wider.
Wider. Narrower, your lordship, for me.
For you, it is
Exactly. Now, your lordships,
the
kindly
becomes
kindly
more.
visualize, your lordships. This is not the first time. I just give an example to your lordships. In counting seniority, everybody made the submissions. This has to be heard by your lordship in extensive. Substantive appointment in a permanent or contractual. This presupposes that there is a regular method of appointment. It subsequently may be quashed by the court. That's a different issue. It must be, even a contractual appointment must be through a regular basis. Like what? There must be an advertisement. There must be a sanction of the government. So this is not there. What they are saying, college fund give me. Well, it will make the Pandora box open. Everybody will come up with tomorrow and say, I have been appointed by the school. So this presupposes, your losses, kindly, my lord, if we read in between the lines, it means even in case of contractual appointment, the appointment must be through a regular mode. Now, your lordships will find in our High Court also there are contractual staff. Oh, my lord, I am not running.
1 minute.
I'm not running comment. So this is, my lord, made by an advertisement. Then your lordships, someone is recruited. Whether those persons have the minimum qualifications, this is not at all done here. So this is not even the contractual appointment as conceived by the rules. This is one thing. Well, your lordships will get it. One of the example I give your lordships in counting of seniority. Suppose your lordships, I have been working in an organization. I am absorbed. Now, question often comes up before the Supreme Court, whether the period before absorption, which I work, will be counted towards the seniority or not. Malad, there are decision of judgment Supreme Courts that in not all cases, this should not be counted. So these are things to be heard. But I find also, Malad, one Malad in CAN application, contractual point is taken in the SLP. But your loss is one.
The rule is being challenged and that issue is
No,
there.
Malad, the contractual appointment given, Malad, if I take your losses, but I must tell your losses, point is in private institution. Contractual appointment, whether they cannot be given the 10 marks. So one way or other, that is also before the Supreme Court. So, my lord, this, because of this, I have taken out application. My right affects because of their petition.
How about that? My lord, only one thing, your lordship can send it to the commission, they can decide it, they reject, so that I can even come before your lordship. Taking the matter pending, my lord, will make it infructuous, my lord, everything will be over.
No, everything subject to the result of the writ
Your
petition.
lordship knows that.
You want a disposal?
Yes, my lord, let it be.
No, commission is not in a position to, with greatest regret,
Reject.
let it be decided once for all. File an affidavit,
Report filed by the District Inspector of Schools, Secondary Education, Purva Bardhaman, and the District Inspector of
We'll
Schools,
file an
Secondary
affidavit.
Education, Murshidabad. Both dated 13th November 2025, filed in court today, is taken on record. The petitioners pray for grant of 10 marks, grant of marks on account of their prior teaching experience. Stop. According to the
Kindly do not delegate it to the commission, kindly decide the question. I want to
sir.
use an affidavit.
At this stage, the court will not decide at all. The process is on. You take a decision.
That will give a new armor to the petitioners. They will come, in the event, the order goes against them. They will come now by a substantive challenge thrown to the rules.
Then that is pending before the Supreme Court. It is already there.
The rules will to that extent, the substantive extent.
According to the West Bengal School Service Commission, bracket open, selection for appointment to the posts of assistant teachers for upper primary level of classes, bracket open, except work education and physical education, comma, classes 11 and 9 and 10, and classes 11 and 12, page 130. Rules, comma, 2025.
They are not in that.
Prescribes prior teaching experience prescribes marks for prior teaching experience in service in a substantive post within bracket as permanent or on contractual basis. Stop. Whether the petitioner be entitled to the marks allocated for prior teaching experience is to be decided by the commission. Stop. The copy of the report has been handed over to the learned advocate for the commission for onward transmission to the authority for taking a decision as to whether the petitioners would be entitled to any mark for prior teaching experience. Stop. A decision shall be taken by the commission at the earliest, and the fate of the petitioner's prayer for grant of marks upon consideration of their prior teaching experience shall be communicated to them without any further delay.
Kindly record that we intended to use an affidavit.
The in view of disposal of the writ petition, comma, the connected application stands disposed of. Though the commission sought for a direction for filing affidavit in the matter, but as the issue is being relegated to the commission for taking a decision, accordingly, the court is not inclined to grant any opportunity to the commission. for filing opposition. Service is taken on record.
Reply obliged, my lord.
My lord, can a time be fixed within this?
I have mentioned earlier, they are going according to their own schedule. I do not want to disturb it.
Item number 4, my lord, I appear for the petitioner. In this matter, my lord, the rule is under, my lord, I have prayed for modification of the rule. This
Which
teaching
is-
experience. No, the same rule, but that teaching experience part. This part is not,
Previous direction to file an affidavit.
my lord, this
16th
part is not under challenge before the Supreme.
I'm seeking your lordship's kind leave to file an affidavit.
I have challenged the rule only to that extent. Well, I am from Army Public School.
Whether you will be entitled to that marks or not.
Yes, I am from Army Public School.
What is the stand in the report?
The report is, it is not a government school.
You've given a copy?
Yes, yes, yes. It's a private school, my lord.
It's a private.
Army public school
It's
treated
a
to be a-
Controlled by the
a
central
society,
government. But
where the central
society-
government has no deep and pervasive control over the affairs of the school, and that is our stand, my lord, and therefore, my lord, this
Lord.
is what the Honorable Supreme Court has said, my lord, in 2025 SCC online 1192.
Yes, yes, that is all right.
Subclassification on the basis of teachers from government school and private school, my lord, is a violation of Article 14. And when any CBSE school or ICSE school, my lord, is been granted no objection by the government of West Bengal. Because, my lord, any CBSE or ICSE school is a Central Board of Secondary Education school. To function any school in the state of West Bengal, mandatory no objection is required. And this school has also been granted no objection by the competent authority of the school education department. The notification, my lord, I have just got yesterday. I have not given the entire list of school, but my school is there. একটু pencil দাও তো। এটা pen দাও না রে। Pursuant to the order
But
passed
we have
by
served the report on
this honorable court.
22nd October, my lord, they have not used any exception, if at all.
This is a point of law. What
Your
But he is
question of-
relying on documents, yes, to give
I
us
mean,
documents.
it's a your document. It is your document. No, no, no.
আমার document কি? আমি কি?
State of West Bengal.
I'm
State
not
of West
government of West Bengal.
No, no, I get it, but then
Lord, just I'm reading the first page notification. Next page is, my lord, the school, my lord, I have shown what is the list of schools. In compliance with the order dated 17/8/2023 passed by Honorable Justice such and such of Calcutta High Court in the matter of 8286 of 2023 Birla Bharati Guardians Welfare Trust versus the state of West Bengal, list of affiliated schools in West Bengal, affiliated with the West Bengal Board of Secondary Education, Central Board of Secondary Education, including Kendriya Vidyalaya, Jawaharlal Navodaya Vidyalaya, Railway Schools, Army Schools, and Air Force School, and the Council of Indian Certificate of Examination CISE schools as received from the concerned boards are uploaded herewith. So all these schools, my lord, there was a big list. I have just indicated the page, my lord, where my school is there. There are around, my lord, 1000 or schools which has been granted no objection by the state. So whether it's a private school or a government school, when the government accepts this no objection and allows the school to function, and, my lord, it accepts its curriculum, everything, then, my lord, government cannot come up and say that we will subclassify into a teaching staff of substantive posts of government schools and private schools. For this, my lord, I will just take your lordship to the division bench judgment.
show me your appointment letter or something. Where are you working?
Page 22, my lord. It has been certified by the competent authority of the school.
Army Public School, Panagarh.
Panagarh.
Affiliated to the
Central Board of Secondary Education.
Hmm.
Admittedly, this school is having no objection of the state of West Bengal. Now, this is to certify that Mrs. Pushpita Chando has worked as PGT, TGT on ad hoc basis at Army Public School, Panagarh. The individual has rendered her services in the following order. 3rd April 2019 to 31st March 2020 Physics, 21st August 2021 to 31st March 2020 Physics, 9th May 2020 to 31st August 2020 TGT Science, 3rd July 2023 to 31st March 2024, PGT Physics.
See, now assuming that it is taken as a government school, can your ad hoc basis service be treated as contractual?
No, it is a
and-
private school. It's a private school. It's a
Maybe
private
it's
school.
private, but it's not a permanent job. They will now come up and say your rules require
My
something
lord, or contractual is also there. All
permanent or contractual.
contractual. So I have challenged that part of the rule. My lord, just kindly come to the object as my lord, in Article 14, every classification have a relation with the object that needs to be achieved. My lord, these are division main judgment. My lord, kindly see the object of this. My lord, paragraph 35. Paragraph 34.
Paragraph 34 is a big one.
Division main judgment. My lord, it will just, it will not take much.
Portion.
34. My lord, just I'm reading it from the top. It will not take much time. The awarding of 10 marks as an weightage is given on the basis of experience and only expected in the selection process of the nature and kind. All candidates are required to undergo rigorous selection process. In order to select the most suitable candidate, proportionate to weightage based on the length of experience to the extent of 10 marks to be given to the candidate is not arbitrary. The object is to select and appoint experienced teacher. But if this is the object, as settled by the division bench, well, then it cannot go, well, subclassify under Article 14, that this is from the government school, we will not take it from the private school, because all private schools in the state of West Bengal are recognized. Suppose, my lord, my school have no recognition. Then, my lord, the state may come up and say that we will not treat the experience of this particular school. And my lord, furthermore, in this matter, my lord, rules, your lordship may come to page 23. The rules are more stringent and student-centric. So they have to take the best teachers. If I have an experience from the public school, private school, my lord, I will be better than the freshers, at least from the freshers. So this type of subclassification, that the state will take only from the government schools, sanction post contractual, are categorically violative of Article 14 of the Constitution of India. In page 24, it was specified the rules has not been challenged by any of the appellants in that particular matter. But here, my lord, I am challenging only that portion of the rule which discriminates among the teachers of the government schools in sanction post, contractual and permanent. Because the term is, my lord, experience. I am not praying for regularization. I will get 10 marks for experience. But if experience is the object of the state, then why to discriminate on government post, sanction post and all? Man, it is a competent school authorized by the state government to function in the state of West Bengal.
How many years did you teach over there?
From 2019.
Not on continuous basis. From 19 to 20?
Well, during the
1
COVID
year.
period, it was a bit.
That means it goes 1 year. And then August 21 to March 22, not even a year. May 22 till March 23, not even a year. And July 23 till March 24, not even a year. At best 2 marks you can get.
At best 2 marks I can.
Assuming.
But 2 marks in a competitive exam
Is
huge.
a lot.
Is a lot.
I understand.
My challenge is, my lord, they cannot discriminate on private schools and government schools when the state is recognizing the schools. Well, there was a division bench judgment of this honorable court, though the doctrine of proportionality was applied to visualize, my lord, not this one. Because the teaching experience, the rule was set aside of this West Bengal School Service Commission old rules because the teacher had experience from the state of Meghalaya. So since it was a different state, that's why the doctrine of proportionality in that matter came into picture. But so far as the schools of state of West Bengal, they are already giving no objection. So it is already proportional. All schools in state of West Bengal. And a list has already been published pursuant to the order passed by this court. Pradeep Kumar Kothar. নর্থ ইস্টের ছিল সেগুলো ডক্ট্রিন অফ প্রপোর্শনালিটি ছিল, ওয়েস্ট বেঙ্গলের হলে তো সেটা হচ্ছে না, মধ্যে দিতে বলছি বলছিলাম নর্থ স্টেটের
দেখুন রিটেক কি আমরা দিয়ে দিয়েছি,
আমার তো রিপোর্টে এত ফাইলের রিপোর্টে কোনো বসে
ফুল আনসার এটা রিডিংটা দেখবো স্যার। আমরা দেখতেছি
Yes, the commission, assuming it is not a government school, idea is to get hold of experienced teachers. Why not a teacher in a private school get the same benefit as given to the government teacher?
First of all, what case he is running now?
He
What
is
is the
running
case?
the case of discrimination.
That case is, he has said that army school is run by the Ministry of Defense. With this sort of a pleading,
He forgoes that. He says that it is a private school. Assume the ultimate, the last thing. If the object is...
he is not even a substantive teacher there. Kindly visualize, our rules stare at his face. And, if everyone today, the pleading is PGT, TGT.
Postgraduate teacher.
PGT teacher. For a limited capacity. For a limited period. He was discharged, she was discharging. Even if we assume that we have the highest sympathies for her, the rules cannot be stretched to that extent so as to include each and everyone.
No, now discrimination issue is coming.
Discrimination, there is no discrimination. We are seeking to restrict it to teachers who are working in substantive capacity or maybe in a substantive post in either permanent or contractual capacity. That
In
is
a
our
government
rules.
school.
In a government school or government aided school. Admittedly, these schools, today, kindly look at it from the other angle. When these rules were framed and when she applied for the post, today she is interested in the marks. She knowing fully well the consequences of the rules and the provisions
Which
of
rules?
the rules, 2025 rules.
No, this has come into effect later on. She joined in 22,
No, no, no.
20, 21.
She applied in this selection test post rules.
Yes, yes, obviously. Otherwise, how could
So,
she?
post rules, she was well aware, these are the provisions in the rules. And in that event, if today,
She is competing as a fresher. No doubt about it.
today this is taking, with all humility, if I may say so, this is taking a calculated chance.
Yes, yes. That I can understand.
And kindly looks into the prayers. My learned friend, very rightly points out discrimination without even saying, without even drawing your kind attention to the praise and the substantive reliefs prayed for. She has sought for a declaration that this should be included. This should be given in the rules, provided for in the rules. Asking the court to review it. So, today, if your lordship is, with, kindly pardons me for saying this, with pleadings which do not run the case that is being run in court. I will invite your lordship to defense.
Para 3.
Paragraph 3, kindly see. Kindly see paragraph 3. If this is the substantive pleading, page 3 bottom and page 4 top.
Para 8.
Local military are established in this. The society has its officer at Shankar, Bihar, etc. It has 12 institutions.
Paragraph 12.
The Ministry of Defense and its schools are associated with the army.
Paragraph 12. Control is something different, my lord.
And today,
aided, unaided is something. Private school means they do not.
I did not interrupt Mr. Banerjee, Lord, I was only humbly beseeching your lordship, if all schools which are listed schools or the government has issued an NOC, if those schools all the teachers say that I am entitled to government scales of pay and I should be paid at par with government teachers, then that is another aspect. There also maybe some sort of a discrimination there. Someone who is knowingly working as a TGT or a PGT for an intermittent period in a school which is absolutely a private school, not run by any state aid, whether such a teacher is entitled to this benefit, your lordship will kindly permit us, again, I repeat, with all humility, if your lordship wants, we can use an affidavit. There is no question.
I have already filed it.
We have used an affidavit. We are relying on the
12, I have stated categorically there is a class among a subclass. There is a classification.
Paragraph 8, kindly see. Paragraph 8.
Your prayer is for declaration?
Fourth prayer. Declaration and D, prayer D.
Commanding any to appropriately modify.
Modify, amend.
And to enable the petitioner to avail the benefit. But your teaching experience is not such. This is what I am seeing. PGT, TGT, TGT, PGT.
But PGT is a all over India term, trained graduate teacher.
Yes.
PGT is postgraduate teacher. Generally, trained graduate teacher teaches up to class 10, 9, 10 and postgraduate teacher teaches up to class.
Capacities.
Whatever may be, that is an experience. I am not praying for regular scale.
Report in the form of affidavit on behalf of the commission filed in court today is taken up. List the matter for hearing on 2nd December 2025.
2nd December?
My lord, kindly pass, my lord, all actions
We have,
taken shall
we
abide
have-
by the result of the writ.
My lord, we have used an affidavit. Kindly take it on record.
I have kept it.
Also relied on the judge.
It is not required to be recorded. It goes without saying. Yes, next.
Fine. Lord, I beg to appear on behalf of the petitioner. This is regarding the second SLST, OMR and model answer key mismatch and anomalies of 6 questions. Well, before I start, may I seek your lordship's kind leave to call my 2 clients because it's a technical subject of nutrition. I might require their assistance showing the questions and answers. May I just call them?
No, if you do not know, then the court also
No,
doesn't
I know. In case.
If it is
because
technical, then the court will also not know.
I will not drag your
And
lordship.
Mr. Bhattacharya will surely not know.
No, I will
And
not.
even if he knows, he'll say he doesn't
I
know.
will not drag your
No,
lordship
if
into
my
the
lord
technical.
doesn't know, how will I know?
Nobody will know if it is a
My lord, on
technical
a
issue.
very lighter note, my lord, how will I know if your lordship doesn't?
No, nothing.
No, very well, my lord.
What?
One thing, my lord. I may not.
My lord, may
I
your
am.
lordship short, my lord.
Yes, I will take some time to place it, my lord. My lord, if your lordship permits, just few things.
You place if
Yes,
required,
yes.
will be seen.
My lord, there are 3 types of anomalies in the whole issue. First, wrong evaluation, despite having the specific answer at par with the TB number books, ISSB and an ISSN acknowledged book by the commission. Despite the specific answers are there, my clients were not given the appropriate marks. Separate options have been allowed by the commission. One. Second type of is this. There were out of syllabus questions. There is a syllabus given by the commission as well as 11-12 syllabus is there. There is out of syllabus question. 2. Third kind of anomaly, that is killing the competitive edge by giving marks to all when there are specific answers to certain questions. Suppose sun rises in the east. North, south, east, west, 4 options are given. Despite the east is the answer, marks have been given on attempt. So it destroys the competitive edge over the person who has rightly marked east. Others are also getting for marking north. So this is how the competitive edge has been destroyed.
How will sun rises in the east, somebody marks north?
In case, I'm giving an example. In case those are specific answers from the books we can show. Even if I'm just giving an answer. It is as easy as that answer, but they have given answer to all, marks to all, that they will get, whoever attempts the question, they will get the marks. Killing the competitive edge.
That means no examination. Whoever appears will get the
Whoever
examination.
marks anything ABCD will get the marks, despite there is specific answer.
To say.
I'm showing. Now, my lord, there are answers. First, there was one preliminary model answer key. Because the nutrition subject, I will show to your lordship why. Because that is a technical subject, I will show. First, there was a preliminary model answer key. Certain answers were given. Now the result came out. The final model answer comes. Commission grants permission to the candidates to apply if there is any objection. We also raised the objection before the commission within 7 days. No answer was given. Now from the preliminary model answer key, it changed. In the final model answer key, it changes. That may so happen. Now I show. My lord, kindly come to page number 65 for once. I'm showing
the advertisement first.
Advertisement.
Or the rules.
Yes, I'm showing.
Where the stages are mentioned. Dates of the examination, the uploading of the preliminary, the model answer key. If there is anything mistake, you are to apply. The dates are all given. Where are those dates?
I'm giving, my lord. This is. I mean, these are the notifications also I'm giving.
Yes.
The notifications are also there.
Yes.
Just one copy. Lordship will find that giving the model answer keys, it is given.
Yes, the dates. Where are the dates given?
No, dates are on 7th, 14th of September. Examination took place.
14th
7th,
September.
7th was the result was out with the model answer key. Then, my lord, I will show from the writ petition. They have given 7 days time. Your lordship will find one notice also where they say that you can give objection to the expert committee. Your lordship possibly has considered that document.
The method of SLST selection.
Yes.
You have a copy?
No, I do not have a copy.
You must be having a copy, otherwise.
Kindly see the second portion, my lord. It says the 11-12, last paragraph, it says any objection if you have, you can raise. I can also show from my writ petition.
the Central Commission shall publish in its official website preliminary model answer key and may invite suggestions and objections.
We first, after the preliminary,
And it has to be done within 5 days after publication of such model answer key, supported by at least 2 authentic.
yes, we have done so. I have done so.
There is no result.
No result, nothing,
report,
no answer.
No
Now
response.
no response. Now I'll show my lord the question. Kindly see from the textbooks. I'm already
No, I'll not go at all.
Just one example I may show.
I will
May I
not
show
go
one
at
example?
all. Nothing. The Central Commission is to form an expert committee.
Yes.
And the commission shall finalize and upload
Yes.
the model answer key.
Yes.
So you got to know that the answer that you marked was incorrect, possibly.
There are 3 types, I can say. Despite there is a specific answer of A, finally the outcome in the final model answer key comes to B, which is supported. My answer is supported by the records, the books. But in the model answer key, it is B. So I lose 2 marks there. There are
So
2
you,
questions.
did you, whatever is the Central Commission's expert committee report will be considered. Where is your objection? Please show me.
Yes. My mail, Lord, kindly see. This is in volume number 2 of the writ petition. Kindly come to page 325. I show how the commission had given me 7 days time. Page 325 at the top. It came at the bottom of my result. That's 7 days time. Now
I didn't get it. Page
325 of the volume number 5, volume number 2. 325. 325 top.
Yes, 325 top.
It came at the bottom of my answer. This is result. So within 7 days, the discrepancies were directed to be filed with the commission.
325 is a disclaimer. It's a print result.
No, it came. Kindly see the previous page. It
Yes.
came with this beneath the result. They say if there is any discrep. This is the result. Kindly see to 325 now. That 325 says that this is a comprehensive result. For any discrepancy, please contact with the commission. And it is also there in the rules I handed over. Rules, there is a provision that if there is something, I can draw the attention. Please.
No, prior to the declaration of the result, where is your objection given in terms of this rule
Unless
11?
the final model answer comes, I cannot raise objection. I cannot see my marks also. It comes with
It
the
is
marks.
not a question of seeing the marks. The Central Commission shall publish in its website preliminary model answers and objections are called for. Those objections are placed before the expert
It is not
committee.
that objection. I tell you, Lordship, there is a difference. First, my lords, they come with one model answer key. People may have objections. They raise the objection. It goes to the expert committee. Expert committee comes with the final model answer key. Now the discrepancy is in the final model answer key, which is not going with my answer key, despite I am having the support of the books.
Yes. So final model answer key was published when?
Final model answer key filed on 7th of November. 7th of November with the model, with our OMR sheets, the final model answer key came with the result, with the marks we have obtained. That came, I showed page 323 with page 3.
Were you okay with the preliminary model answer key? Were you okay? If you were okay,
there is a
then
change.
how will
Yes,
you
because in the final model answer key, the answers got changed. Suppose, my lord, there is one option A. I am sure that option A is acceptable for me. Now, in the final model answer, in 2 questions, that got changed to C. Now, the question of anomaly comes. From the preliminary, there is option A. In the final model answer key, the option is C. Now, I raise the objection that C, it should have been A. You have given C.
All right, page 324 is the
326 onwards, I raised the objections on 11th November, 12th November. Constantly, I have raised objections to the authorities, but no result has been, it has not been considered.
All right, let me hear the
Now,
commission
just one thing, my lord. Now the result have come up.
Hmm.
Now we have got rank 18 and 20. Now 1 mark will take us to rank 2, 3. And your lordship knows the consequences. I will get the options of the schools nearer to my house and there are consequences. So my lord, if your lordship is not willing to see the questions at all,
Not at
I will
all.
not drag your lordship
Mm.
because it is a technical issue court may not enter into. But there are at least 6 questions out of which I will get 4 marks at least, for which, my lord, there are answers I am correct, supported by material records and books, which
It
has not
is
been.
there in your objection raised, page
Yes, yes, yes,
328.
yes, yes, 326 onwards, everything, not once.
326.
Onwards, that is of 12th November. Kindly see your lordship will.
The issue now is that the final answer key got changed from the preliminary answer key. Maybe
I
after
am not ready to reply to that.
I
particular
understand.
Because it is not, the case is not made out.
Yes, yes, yes.
Papers are next.
No, the case
I've
that
made
the
out.
answer scripts were changed.
Yes.
I have not taken instruction to that effect.
Is there in the writ petition.
But Millard will, is Millard looking at 16th September's notification?
Mm.
Rule 11.5.11.
15th November, I see.
Millard will then first see the rules. Thereafter, Millard, I am taking Millard.
Yes, 16th September notification has been handed over.
So, Millard, 16th September notification, according to the 16th September notification, Millard, 25th September, within 25th September, it has to be, the objections has to be raised.
His issue is
the answers changed?
Answers changed at the final answer key stage. And then there is a mention that if there is discrepancy, you can contact within 7 days.
That discrepancy is not answer key discrepancy.
Yeah, of course.
That's result discrepancy.
I don't know.
That is a general disclaimer, but this cannot be linked back to the 16th September notification.
Whatever. But then your the schedule that has been
Millard, the difficulty of change of answer script, Millard, I am not equipped because the case, so far as my understanding goes, is not made out in the writ petition.
I have
your rules say so that the commission shall finalize and upload on its website the final model answer key based on the decision of the
It was done.
and evaluate the OMR on the basis of this and the final model answer key uploaded in its website. Right. It is at this stage that he is having some problems. I am not sure.
Millard, I do not have this particular instruction because
Right.
the cases were not there.
Why don't you consider
Yes.
326, 27, 28? Possibly it is the same thing.
Yes, the dates are different. 11th November, 12th November. Constantly, I have written to the authorities that as per
12th November, he has written, I am not rejecting, saying anything.
That I understand.
Publish it.
7th November. 7th পড়েছি 7th পাবলিকেশন হয়েছে তো 7 দিন মানে 14 তারিখ 7 তারিখে তো 7 তারিখে এর সঙ্গে পাবলিশ হয়েছে তো তো আমাদের র্যাঙ্কের সাথে এই মার্কসের সাথে এসেছে ফাইনাল মডেল আনসার কি we have also like
Please come.
My lord, only one submission, one humble submission before lordship, my lord. My lord, this same now, if it is reevaluated or seen, the same expert committee will be doing the same exercise. But I have challenged that the expert committee's decision of changing the answers. Now, my lord, if the same expert committee does the same, they will be sitting on their own case. I have made a specific prayer that in my prayer that an expert committee be formed to see my objections are correct or not, because he will be hearing his own case. Because they have already explained it.
In paragraph 5 of the writ petition, the petitioner says that after publication of the OMR sheets in the official websites, the commission's written examination, the petitioner found the discrepancies are there.
At the initial stage only they found discrepancies.
That is para 5.
No.
What?
OMR sheets and model answer key came on 7th
September.
Petition state that after publication of the OMR sheet and model answer key in the official website, model answer key came on 7th. After that, they gave us.
No, model answer key preliminary came long back.
On 20th September.
That is the first model answer.
Where?
He has made
Yes, I'm showing. It was the first model answer key. There are 2 model answer keys. I've annexed it. There are 2 model.
Yes, I can understand preliminary and a final one.
Yes, after the and the model
Go
answer
out
key.
from the petition that with the preliminary model answer key it was all right, but at the final stage it got changed. Show me the preliminary answer key.
I'm showing.
And what is the change in the final one?
Yes, I'm showing. My lord, kindly come to answer key, page number 74. 74 of the volume 1. No, this is the final model answer. There are 3 documents.
Preliminary one.
Preliminary, yes, yes.
74.
No, no, 74. Preliminary. 78 is preliminary.
78.
78. This is the with the master key. My lord, kindly mark the master keys, because according to the master key, the answers will be changing.
78 is the.
78. My lord, kindly see. I give one of.
This is the preliminary one.
This is the preliminary one. Yes.
Where do you get the?
And 77 also. 77, 78.
All right. Where is the date to show that it is a preliminary one?
Because the final one is at page 74. This is how they have published in their website.
All right.
Page 74 is the final.
This is preliminary.
There would be 3 documents. 74 is the final. 77 shows the master key along with the series, and 78 would be the preliminary. Now, my lord, there are changes. I show. If your lordship kindly takes first the page 77.
Page 77.
Yes, my lord, kindly take question number left hand side, master 1, 2, 3. 3. Kindly see the series A, question number 26. 26 would be the question number. Master key is 3. Series booklet A. Right? My lord, kindly come to this page 78. This is the preliminary model answer key.
Yes.
It comes C, 3, master key, left hand side, 3C.
Yes.
Now, my lord, kindly come to page 74, which is the final model answer. It is written as final. Kindly see the second column. Kindly see 3 comes to A and C.
কোনটা দেখালে দাদা? সরি,
3 নম্বরটা। 3 নম্বর।
78 এ কি দেখালে?
78 টা হচ্ছে 3 এটা হচ্ছে তোর প্রিভিয়াস মডেল আনসার কি?
3 তে সি।
3 78 এর 3 তে হচ্ছে সি, শুধু সি ছিল। আর এটা 74 হয়ে গেল এ এন্ড সি। Now, my lord, next kindly take 32 at page 77.
If the petitioner had given
Page 32.
Page no, 77. Page 77. Kindly see this right hand side column.
32.
32. Question number 59 of A booklet. My lord, kindly come to page 78. Answer was D. Page 78, right hand side.
Yes.
Now, my lord, kindly come to page 74. 32 to 74. That is page 75. Page 75, left hand side, marks to all.
75 marks to
75,
all.
Left hand side, marks to all.
Yes.
This is one. Now, my lord, they have given option, specific option in other questions.
That means you say that what you answered was all right, but then others have also.
They are going up above me. One. Second, your lordship, which has not seen by your lordship, there are specific. Suppose there is one from the petition. I'm saying how much iron is needed for a pregnant woman. That is 21 mg. From all the books I can show. They have given marks for others also. 14 mg they have given marks. 13 mg they have given marks. Cannot be. There is one specific answer from the book. You cannot do it. Now, my lord, there is out of syllabus questions.
And was it there in the preliminary answer key?
Preliminary, I tell your lordship. I tell your lordship.
What was the answer given in the preliminary answer key?
Preliminary, yes. I'm just give me one moment. Kindly give me one moment. I'm showing. From the petition itself. I'll kindly take my written also, since it's technical issues, page 8, Roman 2. Example I'm giving.
Page 8 of the
State
writ petition.
Volume 1. I have explained it, how the questions have.
No explanation.
But
Just give me
as per the
instances.
textbooks, the only answer will be option D, 21 milligram. But in the model answer key, marks have been given to all of the above options, which is incorrect. As other than option D, other options have no acceptability, for which any competitor in the said examination will get 1 free mark practically. Even if such candidate has chosen any other option than D, it is destroying the competitive edge and the level playing field. You cannot allow this. One. Now, my lord, I come out of syllabus questions, and yes,
But out of syllabus was at the initial stage. Now you cannot say out of syllabus.
very well, my lord. Now the next page, page number 9, Roman 3. With respect to booklet series A in question number 32 such and such, the question serving size stands for there where 4 options were given. Amount served A, B, C, D such and such. Next page, that as per the model answer key, the option A, amount served at a time, has been given as a right answer. But from the textbooks, it appears that both options A and D would be correct and suitable. I have marked option D since A and D both are correct, but they have chosen only A. So I have suffered here. Now, my lord, next, this is very important. This one is very evident. Kindly take the Roman 4. The question came, no protein supplement is required other than daily food habit for majority of athletes. This guideline is given by 4 options. I have marked Sports Authority of India, which is, I have all the books, their guidelines, notifications, everything. But they have not chosen option A. They have given option C, ICMR. Clearly, the documents are showing that it is the Sports Authority of India who gives the guideline.
Felt from Miller's was how was the change happened.
Yes.
We are still trying to.
Please come to page 75 once.
May I just call them for one information? Just
1 minute.
75.
Page 75, I can see there are a lot of markings, marks on attempt,
Yes.
marks to all. What does this mean?
There might.
Is it a free thing? Whoever puts a tick mark, get a mark.
But I understand what is falling from Millard, but this was the expert committees, Millard, who knows the subject. Even I am not an expert to assist Millard with regard to what.
It's not a question of an expert. Thing is, when you give marks on attempt, that means everybody gets that mark.
Yes, even the petitioner.
This is the grievance that you are killing the competitive edge of the candidates.
Petitioner's grievance is the decision of the expert committee. The expert committee is not before Millard's. The petitioner is giving reasons that why, according to him, the expert committee's decision is not apt. Or
you tell me,
Millard,
how come you give marks to all,
I have to
even
take
if
instruction to that.
the answers are incorrect? And how marks on attempt can be given? What type of questions do you all frame? It doesn't have a proper answer.
I will come back on.
And they
this
change
point,
it.
I don't have it.
First, they have an answer.
Not there.
Second model answer,
We
ki
did
no
not
answer.
ask.
Marks to all.
We did not approach
Is it to accommodate others?
for
I
any-
pose this question to myself. Is it to accommodate others?
And
No, it is
the
not to accommodate anybody.
preliminary one, you had only one answer to one question. Pages 77.
That is the reason 16 September notification is there, that if there are discrepancies, if somebody has any objection, within 25th September, they will let us know so that the expert committee can assess the question papers as well as the objection with valid reasons.
That's the previous. I'm talking about the final model answer key, which has changed.
The changing, Millard, even if the point is that he was satisfied with the preliminary answers, Millard, I could not take instruction to that effect because the pleading specifically does not say so. Paragraph 5 says otherwise.
Showing from the documents. The final model answer key changes.
That's why the rule specifically says that the decision of the expert committee shall be binding upon everybody. It is not about the petitioner also, because everybody will be in the same footing.
They have been given to challenge also.
Answers to A and C, if the petitioner has opted C, petitioner will get, A will also get.
No,
that's
Why will you get? This is the issue.
This might be that the experts have felt that both the answers are nearby.
That means the experts have felt that the question was not proper and D is not the appropriate answer. That is the reason even A is given a mark.
I cannot respond to this.
You have to.
I will. But as of now, I cannot respond to Miller.
It has been already, ranks have come up, interview, it will be starting from 28.
If you go by this way, then anybody who puts in the application will be given a chance to appear in the examination. Their name should be there in the interview list. You are making segregation as to whether previous teaching experience in a private school, whether teaching experience in a government school, in an army school, in a Navodaya school, and now here you give marks to anybody.
16 questions. 16 marks to all 16 questions. Kindly see.
This was given.
16 questions.
Some reasons.
Huge. 16 marks means huge. Whoever attempts
Like a
gets marked.
subjective, There must have been some reasons, Milord. It might be like that.
Obviously, there are reasons.
Absolutely.
Otherwise,
Milord will allow
This
us to
could not
come back,
be.
Milord, in this matter with appropriate instructions. Milord, we will assist the court.
please come.
But my lord, the difficulty is, my lord, I'm just praying for an interim order now.
What interim order?
Yes, now my lord, if I get the marks, my rank would be higher at this stage. I'll be at the higher rank candidate. Now, whenever they come, they have published their. I have filed this writ petition previous to publication. I obtained leave from your lordship and I have filed before publication. It is not seeing the result I have come.
So now the interview list has been published.
Now there is a difficulty. They will verify me an interview.
Yes.
Since I'm ranked number 820, I will not the options which are being shown to rank.
That is the time of final merit list publication.
But at this stage, I'll be at a disadvantageous position. My lord,
Why?
kindly protect us. Kindly
What
protect
type
us
of disadvantage
that
at this stage?
if your lordship interferes, then the relief will be given to me.
What type of relief?
That my rank, the marks, if I am given, I'll be securing higher marks. That is to be considered.
That is in the final merit list. It will be shown. Now nothing.
Your lordship is keeping it. Your lordship is keeping it
pending.
For next week, my lord, because the days are very short. That is why, my lord.
Oh.
Timeline is very short. 28 is the verification.
The petitioners participated in the recruitment process conducted by the West Bengal Central School Service Commission for appointment the post of assistant teacher
Post of assistant teacher at 11, 12, 11. Nutrition.
in respect of classes 11 and 12. Stop. Allegation is that the commission changed the answer as was published in the preliminary model key in the final model key. Stop. The final model key was published simultaneously at the time of publication of the interview list. Both done simultaneously, isn't it? Interview list and the final answer key
7th of November.
on 7th November 2025.
But I am told that after preliminary model answer key objections were raised. May I just take one information?
It must be here in your petition.
Yes, it is. I'm just taking one. It is there possible. The documents are attached. May I just call for once.
According to the petitioners, the answer key, now the answers mentioned in the preliminary model answer key differed from what was published in the final model answer key. Stop. On a perusal of the final model answer key annexed at pages 74 and 75 of the writ petition.
Yes.
74, 75 and 76 of the writ petition.
Excuse me.
It has been shown that there are questions where two answers have been found to be correct, comma, marks have been allotted only on attempting the question, and marks have been given to all candidates. Stop. The petitioner raised objection before the commission on 12th
11th also, 11th November, 12th November.
11th November 2025 and 12th November 2025. Up next. The petitioner alleges that candidates who did not answer the question correctly will get an advantage if marks is provided to anybody who attempted the question and despite giving a wrong answer to the same. Stop. Next. It has been submitted that the competitive edge of candidates providing wrong answers to the questions gets diminished if marks is allotted to everybody who attempts an answer question. Stop. Next. The commission is directed to revert with a report after considering the objection filed by the petitioners. Release the matter on first of December.
My lord, one information I've just got. Yes, we lodged the complaint after the first model answer key, and there was no system of mail. In the website itself, there was a portal made from which we could have applied. We applied with payment. We have the payment receipt also. We raised the objection.
Is everything there in your writ petition?
No, my lord, it's not disclosed. Statement I've made. This document is not there. That from the website I can find. There is a receipt also. I raised on 25th of September 2025. That is prior that just after the publication of the preliminary. So my statement stands for it, paragraph number 5, and these are the documents which is not here. So I can place it.
But if the objections were raised, then the final answer key questions were rightly changed due to their objections.
No,
along with them,
we raised objection regarding
Milord,
four
along
other
with them, there were 2.89 lakhs candidates who raised objections.
My lord,
we are considering his case only.
No,
You must be considering everybody's.
That's what we intend to produce before your lordship. What deliberations went through with the expert committee while changing all these questions.
My learned friend is wrong because we raised objection that was not changed by the expert committee. We given documents also to that effect.
It's not disclosed in the writ petition.
Yes, it is. It is in regard with other 4 questions
raised by the petitioner immediately after publication of the preliminary model answer key. Acha. Ki diye shuru korlen? Now, the fate of the initial objection. Along with the
September 25th.
On 25th September 2025, along with the prescribed fee, shall also be disclosed in the report. 1st of December.
1st December. Well, in the meantime, the interview would be completed.
Let us see. Final will be coming after the Supreme Court.
Sit at this side, my lord. Otherwise, no, that is different, my lord. That is a 10 marks. My lord,
Yes,
by that
yes.
time, the counseling would be completed.
Apart from 10 marks, also there are several other issues. Let us see.
Counseling will be complete. I will not get the schools.
Let us see.
Kindly give me some.
May I get the copy of the objections which has been lodged by the petitioner? It is disclosed in the writ petition.
But kindly, I'll
not disclose
objection.
the objection which is being shown from the
their
mobile
commission's portal. Anyways, I'll give them. No
phone.
problem.
Not disclosed in the writ
No
petition.
problem.
Then please.
Of course, but I'll be in difficulty if counseling is held today. If I am called after 18 persons, now 18 schools will be taken away.
No, counseling will be held. It will take time. Let the final result be published.
Kindly keep it after the verification, not at 1st December, my lord. That I'll be in difficulty. Because by that time, situation will change.
And how soon are you expecting the verification to be over?
28th is the verification.
Verification will be over, my lord, by the end of this month.
4th December is our verification. I am told 4th December
Yes.
is our verification.
So I've kept it on the 1st.
Very
On the 1st.
Very well. My lord, at the top, my lord. That is
These matters are already at the top. Urgent motion, keep it as urgent motion only.
Grateful, my lord.
Item 77 is also regarding OMR sheet matter, not the similar matter.
My lord, it's a different matter.
আমি বলছি তো বাবা, আমি তো অন্য কিছু বলছি না।
Just wait.
Very
I'll just call through. Yes, next.
I'm grateful to your lordship.
The director's matter, my lord. The application which is pending. The lordship on the last occasion was supposed to direct the opposite, the respondents.
There are 9.
Has any appeal been preferred against the order passed by the?
I have no instruction as yet, my lord.
Nobody preferred any appeal?
Till date, I don't have any instruction.
And any development or the same impasse is still continuing?
I have.
But I believe not there is no such impasse as of date. But things have almost regularized as we come to know from the newspaper and reports.
Don't find newspaper reports.
Don't have such instructions, my lord.
Are your clients in a position to work?
Lordship, 2 of them are not in a position to work, my lord.
Others have?
Others, my lord, I have no instructions.
But as we come to once again, not as we come to know from not common knowledge, not they are working. It's once again a newspaper report.
My lord, may I beg for another adjournment, my lord? In the
Certainly.
meantime, if they call.
On the prayer of the learned advocate representing the petitioner, release the matter for further consideration on 6th of January.
6th of June.
Of? Who are you?
We have,
The direction was there.
Yes,
Who are you?
For contempt number 229.
One lord, in fact, in terms of your lordship's order, 10th of September, direction was given upon them to serve on the alleged contemnor. In course of the hearing, I was informed that I am appearing for one of the alleged contemnors, but no copy has been served.
See, if it has not been served, then please. All right, next. 7.
Seminar.
All right.
Madam, in the matter, I am for the state matter. I am here for the petition.
Yes.
The petitioner is not getting pension, my lord.
Why?
My lord, the is that, my lord, the school has intimated the petitioner that my lord, she has overdrawn some amount. When the pension papers were processed, my lord, it has been detected that the higher scale which she enjoyed, my lord, and the DI has granted to her, that was illegal. My lord, in terms of Rafiq Masi's judgment, my lord, at this stage, my lord, overdrawn amount cannot be claimed. And my lord, for that reason, the pensioner benefit has not been released. If you lordship kindly have a look, my lord, the last page, page 18. Now, this is the communication I have received from the school authority. Kindly see, my lord. This is to intimate you that apropos objection dated 28/10/2024 from DIN regarding pension application, we have reviewed the pay with effect.
Show me the portion that you are required to refund.
Yes, that is written here.
3 lakh?
Yes, 3 lakh and something it has been written.
3 lakhs.
Tentatively more than 3 lakh. But this is the only communication I have received from the school.
And since when are you receiving this?
From 1999. Lordship kindly comes page 17.
Yes.
This is the later, my lord, postgraduate scale of pay sanctioned by the DI.
Yes.
Well, in reference to the subject mentioned above.
2002.
2002.
Right.
So I have been enjoying the postgraduate scale of pay. Now at the verge of retirement, when pension papers are being prepared, they said that I have wrongly received the honors, the postgraduate scale of pay. So that cannot be, my lord, at the verge of retirement, and the lordship is well aware that the Supreme Court judgment, my lord, it has been said.
Which portion to look into?
My lord, the petitioner, my lord, kindly come to instruction, my lord. It's one last, the bottom, my lord, one. Roman 1, my lord. If the existing pay is lower than the minimum of the shall pay the fixed minimum of the higher scale, my lord. My lord, petitioner received excess payment, my lord. There is overdrawn amount. But she did not refund. This is my submission, my lord.
Page 17, 2002, communication. sanction of postgraduate scale of pay.
Yes, my lord.
Is this incorrect?
No, my lord, it is correct, my lord.
Page 17 is correct.
Yes, my lord.
Then where is,
Sanction post.
then where is the overdrawn amount?
Yes. My lord, in my instructions, my lord, kindly see that the school authority had applied postgraduate scale of pay in favor of the petitioner
Hmm.
on 7th March 2001, as per the government order number so and so, had sanctioned postgraduate scale of pay. File memo number so and so.
This memo,
Yes, sir.
page 17.
And my lord, thereafter the page, my lord. Right. In my instruction, my lord. T, my lord, 304.6C, my lord. If the existing pay is lower than the minimum of the
Please come. You got my order regarding overdrawn?
Right.
Taken overdrawn.
No refund, my lord.
আচ্ছা ঠিক আছে সেইটা করে দেবেন আর retired from service on
On 31st of January 2025, during pendency of this
Yes,
decree.
my lord. But there was an undertaking, my lord. Even by the petition rejects this amount, my lord. She will refund, my lord.
এটা করে পাঠাচ্ছি দেখছি instruction written with the records.
Yes, ma'am.
You has not been issued.
All right. Next,
I'm dead.
I'm disposing it off.
Good.
I'm appearing for the
State.
state in this matter, madam. Lord has asked me to.
Council was there. West Bengal Council of Higher Secondary Education.
One file.
আচ্ছা আচ্ছা।
না?
এটা অন্য ফাইল দিয়েছেন না 11 নম্বরের ফাইল এটা DI is directed to file a report disclosing the name of the schools close to the residence where vacancy is available.
Madam,
Yes,
the
sir.
report has.
That is 22.
Huh?
The first preferred schools file the school wrote a letter to the commission that this vacancy is lying vacant. They say that the vacancy has been reported to the secondary CLST. The list of the school has not yet been published by the commission.
Only one vacancy is in Daria Jail.
Jail Vidyalaya.
Is it close to your place? Is one of is this school one of the options?
Yes.
Then you can be recommended there. Please come. From the report forwarded by the District Inspector of School Secondary Education, South 24 Parganas dated 13th November 2025. It appears that the school with vacancy where petitioner may be recommended on transfer is এটা লিখে নেবেন তো দারিয়া ঠিক আছে the West Bengal School Service Commission is directed to recommend the name of the petitioner to the said school so that she may join the same on transfer without any further delay.
After its recommendation, board has taken. Board has to.
Yes, issue the letter.
Board is also party.
Right. I dispose it of. Steps shall be taken by the commission, followed by the West Bengal Board of Secondary Education.
No.
Positively,
It shall be taken by the board, followed by the.
commission is going to recommend first,
Yes, then-
and then the board will take steps for issuance of the appointment letter. এখানে দাঁড়াও, commission বলো I'm for School Service Commission.
My lord, I'm from School Service Commission.
Yes. What is your submission?
My senior Kanakiran Bandapati is engaged in another court.
আচ্ছা কি বললাম হ্যাঁ positively at the earliest and the authorities shall ensure that the petitioner joins the transferred school within a period of 4 weeks
Vacancy in philosophy.
from date the
Funding.
petition disposed.
Grateful, Your Lordship.
Yes.
As per the petition, well, as per your lordship direction, I served the copy. My lord, the correct report is not yet received, my lord. The report, my lord. I also, my lord, not yet received, my lord. Correct report, not paid. That is the correct.
Absorption of the private respondent in service.
That's my lord, I sent another.
Your Lordship, I'm my senior, Mr. Vimal Kumar Shah, is for the state. Ma'am, I'm praying for not today, as we did not receive the report. By end of the day, we will get the report and submit it tomorrow, ma'am.
All right, please come. Service upon the private respondent is not complete. Stuff released on 1st December 2025. Service in the meantime.
Much obliged.
Seven, my lord, I beg to appear for the petition. But I am appealing for the school authority. The earlier occasion, I did not able to produce the 31st xerox copy of the. You also directed the council to take further instructions.
Who is for the council?
Yes. The earlier occasion appeared. Challenge the resolution dated 4th September 2025, passed by the council.
Mr. Rotikanto Pal, 7 to 10. Where is he?
Yes, ma'am. Ma'am, I am for him. I am presenting for him. He is my senior. He is engaged in court number 10 right now.
Also, board is also not present. Board present? Board.
You have instructions with you?
Sir, my senior is in code number 35. He's coming.
Everybody is going everywhere. What will I'm passing it over. Yes. Get hold of your learned friends, 2 of them. Yes. 12.
My lord.
My lord, I am for the state respondents, my lord.
My lord, I am, my lord, for the petitioner. My lord, on the last occasion, my lord had directed me to bring instructions, my lord, that when my petitioner, my lord, will return the 8 lakh rupees, my lord, because he is suspended, my lord, from 2021.
All right.
My lord, today in the morning, my lord, I have been informed that the petitioner is expired. My lord will kindly grant me 2 or 3 weeks time. I will bring the death certificate and my lord, I'll produce it before the court. My lord.
Learned advocate for the petitioner submits that he has received information regarding the death of the petitioner. Stop. Copy of the death certificate has not yet been received by him. Prayer for accommodation. Accommodation has been sought for. Stop. Released on 1st December 2025.
Much obliged.
Grateful, my
But in
lord.
this matter, secondary board election, virtually.
For the board. All right. Yes, next.
Lord, I am applying for state, my lord, we need, we want to file a short affidavit.
State.
Yes. But this is with regard to higher scale of pay.
The lordship, my lord, the kindly turn to page 56. Other points, my lord, for rejection of higher scale of pay has been considered and my lord, undone. And my lord, he directed the DI to take a my lord, his lordship also, my lord, the previous petition comes to a conclusion. Petitioner is entitled to postgraduate scale of pay. My lord, now the DI has taken new point, page 65. The School Service Commission Amendment Act came into force. My lord, that is also, my lord, not applicable. That is on another aspect. That is also judgment. And my lord, in this case, particular page 65, Last paragraph, serial number 3. Act came into force on 14 September 2016. You will also got it, my lord?
Yes.
1416. You will also kindly page 39.
Page 39.
Date of completion of 28 August 2016. Yes, they have taken consideration whether the certificate was issued. This is whether the now the DI has whether on the basis of that the even whether the Amendment Act has no manner of application. Amendment Act applies whether to the new income and new teacher.
That is why I am requesting your lordship to give a short time so that we can file a short affidavit.
By affidavit, what will you disclose?
my lord,
But
my
then
lord.
it's page 65 under.
Yes.
Page 65 under challenge.
Please come. The reasoned order dated 24th July 2025 passed by the District Inspector of Schools, Secondary Education South 24 Parganas, rejecting the petitioner's prayer for grant of postgraduate scale of pay on acquiring higher qualification is impugned in the instant writ petition. Learned advocate representing the state seeks time to file affidavit. Stop. Let affidavit in opposition be prepared and circulated by 19th December. Reply, if any, by 9th of January. Liberty to mention the matter.
And record.
Deep level. Appearance to deep level. Deep level. কত হলো
19th of December.
না না
Matter may be listed under the under heading motion. Will also kindly under the
After affidavit, it cannot be motion.
On the date, erroneous date calculated.
no I shall make submission. That is full bench judgment also.
Full bench judgment.
Next.
Passover matter
will be taken up. All parties are here. একটা Passover matter দিয়ে দিন তো।
But I have challenged the resolution dated 4th September 2025.
By the?
I passed by the page 58. Kindly have a look. Page 58.
Yes.
Whereby the President West Bengal Council of Higher Secondary Education passed such an order. I'll kindly come to paragraph 4 and 5.
Yes.
The Honorable President Council will recommend to Commissioner of School Education for taking disciplinary proceeding in favor of Pradeep Kumar Bandyopadhyay. I am for Pradeep Kumar Bandyopadhyay, the petition hearing. HM TIC VL High School. Further, all the leaves taken by Prabhati Bhattacharya, assistant teacher, Real High School, in connection of higher secondary examination 2020, either granted by DISAC, Kolkata, or as per the notification of the council issued from time to time, will be granted, and the service book of the incumbent will be regularized as soon as possible by the school authority in consultation with Kolkata or his representative. The fact of the case is that my lord, assistant teacher in charge of the Behala High School, what happened? The private respondent, my lord, was absent for a period, my lord. That's why, my lord, I supposed him.
You are Pradeep. You are Pradeep. What is the why is Prabhavati coming in?
Madam, is the assistant teacher of my school.
All right, you are the?
I'm the headmaster of the school.
Assistant headmaster.
Yes.
Come, teacher in charge.
The the private respondent was appointed as my lord the nominee of council for my lord going to the my lord, council office for examination. But no scrap of paper was supplied to me, my lord, by the my lord, council as well as the board. My lord, I have made representation to the board as well as council. My lord, kindly come to page 50, my lord. The board has answered. Yes, 50. Regarding unauthorized absence, my lord, board.
Yes.
With reference to the matter as mentioned above, I am directed to inform you that leave on duty may not be considered in absence of proper document, and the managing committee of the school incompetent authority to sanction the leave. But time to time I have approached the my lord, concerned authority, but nothing has been done. Thereafter, again, my lord, the council, my lord, took a resolution, and my lord, the 4th September 2025 order was passed for taking disciplinary action against me, my lord. And council has no power at all. My lord, I am giving the my lord, the my lord, the school education department, the secondary education, my lord, the rules, my lord. Kindly have a look.
2018.
Yes, 2018. Page 5. My lord, kindly have a look. Page 5. Council is established to my lord, organize the my lord, the examination. Council has no power at all.
Powers and duty of the board.
No, my lord. Page 5. Page
Council,
5.
Page 5.
Disciplinary proceeding, my lord.
Yes.
The board may authorize any officer not below the rank of a sub-inspector of schools to conduct preliminary investigation against my teacher or any teacher or non-teaching staff upon receipt of a complaint pertaining to the misconduct of a teacher and non-teaching staff from the committee or the administrator or head of an institution. My lord. Here I have no fault at all, my lord. No scrap of paper was supplied to me by the my lord, private respondent, my lord. My lord, kindly have a look, my lord. The letter, my lord, I have sent to the my lord, document in the hegemony. So many letters, my lord, I have given.
Council. Board.
On 1st March 2025, I sent a letter to the my lord, private respondent seeking explanation against the absence on 28th February 2025. Again, my lord, I have sent letter, my lord, kindly come to my lord, page 34. On 1st March 2025, and I sent a letter to the Deputy Secretary Examination. Information regarding unauthorized absence of Srimati Prabhati Bhattacharya. My lord, she replied, page 35, Sokos Chiti Jawab Dihi.
Yes.
Again, also, my lord, on 22nd March 2025, page 39, I sent a letter to the Secretary West Bengal Board of Secondary Education. Information regarding frequent absence of a lady teacher.
How come the council enters into
Yes,
it? Who approached the council and how?
Well, the private respondent had approached.
Council has appointed Suomoto to the concerned teacher.
Under which authority did you act?
My lord,
Under which authority did you act?
my lord, first and foremost, my lord, since the petitioner is raising an issue with regard to point number 4 and 5, my lord, of the resolution, which has been placed before your lordship at page 58, my lord, may kindly take it up once, page 58.
Yes.
My lord would be pleased to see that the first one, that is point 4, is a mere recommendation, my lord. My lord knows that I am not the authority which can initiate the disciplinary proceeding. That power lies with the board. Rule 5 has been placed before your lordship. I will take your lordship also through sub rule 12, which deals with suo motu cognizance, that is based on any information that the board may receive. This recommendation.
Who are you representing?
I'm the council, my lord.
Council.
Council.
All right. Yes.
My lord, this mere recommendation need not necessarily lead to the initiation of a disciplinary proceeding. In fact, even if the mere initiation of a disciplinary proceeding, if at all by the board, will be in a better position to apprise your lordship of that. That by itself does not give a petitioner a right to challenge it at this stage. This is a mere recommendation. My submission is this is not binding on the board. If at all the board decides, then the board may proceed. Only when a charge sheet is filed in a service matter would the petitioner have any right to come and challenge that before. So this by itself, my lord, is a mere recommendation. My lord, the teacher approached us saying that she had been appointed by us, now my lord, as a council nominee. Now, having done that, when she took dates off in connection with the work that she was in connection with the work that she had been allotted to, regarding that,
She's not a regular teacher of this school.
She's a regular teacher.
Then dates off means
My lord,
she was absent.
My lord would kindly.
No, because the issue arises with absence, isn't it?
My lord, the absence is authorized, my lord.
Absence is authorized.
She has been appointed as council nominee. She has to do her work, my lord. Kindly cease.
A nominee for what purpose? Why don't you intimate the teacher in charge that she is appointed for such and such purpose, something? Did you intimate the school?
My lord, kindly takes up the notification, my lord.
Yes.
This has been addressed to everybody, my lord. Kindly cease. The undersigned is pleased to announce the number of maximum permissible days for which on duty may be given to the teachers for performing HS exams such and such. All the head of the HS institutions, head examiners, scrutinizers, DAC such and such, and council nominee are requested to note the following breakup. My lord, kindly sees all the head of HS institutions. This is the general notification, my lord. Now, my lord, in the complaint that this lady has lodged with us, she says that she had tried to intimate. Firstly, it is an acceptance on their part that there has been oral intimation about this. My lord would kindly take up para 6 and 7, my lord. Petition, my lord. The petitioner cannot say that he was completely unaware.
22nd of February 25.
My lord, it is curious enough that suddenly para 6, my lord. On such and such, the private respondent orally informed the petitioner that she had been selected as a council nominee for the upcoming such and such, for which she would have to visit the council's office frequently during school hours, and accordingly she would have frequent leave on duty. In response, the aforesaid verbal request, the petitioner.
No, whatever. See, in the notification, there must be days and period and time mentioned when the teacher can be treated as on duty. There must be something. Right? So if the issue is with the absence, the board is the authority to take a decision.
No, my lord, there are two aspects, my lord. I have placed point 4 before your lordship.
Yes.
That deals with a recommendation. A recommendation not being binding, it is premature for the petitioner to challenge point 4. Point 5. Point 5 deals with, my lord. My lord would kindly once again see page 58. My lord, point 5 deals with the private respondent who shall make her submissions herself. But even then, my lord, at page 58, my lord would see point 5 deals with the unauthorized absence that this private respondent.
No, that will be dealt separately.
My lord, so the petitioner does not have locus.
Page 58, same thing, first paragraph. Such and such may be removed from duty. You are recommending removal.
Duty. My lord, from venue supervisor of the said venue. That is within our domain. That is
not from service.
It is not from service. Venue is the conduct of examination. That venue supervisor, that is within our domain.
All right.
That is why he has not challenged that. He has only challenged 4 and 5.
His service is not being infringed upon.
Absolutely not.
All right.
My lord, now point 5 deals with the private respondent. Whether her answer is that the private respondent can take up the managing committee.
What is the
Point 4.
We already
My lord,
have 4 months. Paragraph? For paragraph 4.
Only 4.
Page 58. Yes.
Mala, in paragraph 4, what is written, Mala?
Yes.
Honorable President, Council.
Yes.
Yes.
Will recommend to Commissioner of School Education for making disciplinary proceedings. To whom they will recommend, I don't know.
No, it's mentioned to Commissioner.
No, my lord, Honorable President Council, my lord. Not the Honorable President Board. Council. This Honorable President is giving the, my lord, the resolution, my lord. Is giving the, my lord. Kindly see the.
No recommendation.
You say it's not the decision of the council, it's the decision of the president.
No, no.
Honorable President.
Yes, so it is the decision of
President is
the,
writing this resolution.
right.
Honorable President, Council will recommend to Commissioner of School Education. Well, they have to recommend to the board. And board has the duty. Council has not at all any the power for recommending the for disciplinary proceeding. Honorable President, Council will recommend.
My lord, as a matter of
The language, my lord, it is written, the Honorable President, Council will recommend.
That means your submission is that the president independently is recommending and not the council.
No.
Sorry, I cannot follow.
President
What
Council
is
has
the
no power at all for
board has nothing
recommendation?
to do, my lord.
board has nothing to
My lord,
do?
he is, my lord, regarding para 4, my lord, this president council will recommend it to Commissioner of School Education, not to the board.
Yes.
It's among themselves, my lord.
The board has
My lord,
nothing to do,
board
and the
has nothing
Commissioner
to
of
do, my
School
lord.
Education also doesn't have anything to do in the matter.
It's regarding, my lord, disciplinary proceeding, my lord.
Commissioner cannot do anything.
Madam, authority only the power has,
My lord, 1,
What
2,
board,
3, and 5, there is nothing, my lord.
the power is vested upon the board.
My lord.
Council has no power at all.
My lord, may permit me to place this judgment.
What is it?
My lord, a judgment, my lord.
মাননীয় বিচারক
My lord, first, as a matter of record, my lord, no recommendation has been made on the part of the council as yet. I am submitting on instructions.
You have not recommended.
No such recommendation has gone.
From September till end of November,
such
mid of
recommendation.
November, you have not yet made recommendation. Please come.
Then nothing.
The petitioner is aggrieved by point 4 of the resolution dated 4th September 2025 by the President of the West Bengal Council of Higher Secondary Education. Stop.
মাননীয়
The petitioner is serving as the assistant headmaster cum teacher in charge of Behala High School. Stop. He is aggrieved by the decision taken by the president of the council to recommend disciplinary proceeding against the petitioner before the Commissioner of School Education. Stop. Learned advocate representing the council submits upon instruction that till date no recommendation against the petitioner has been forwarded to any authority whatsoever. Stuff. As per the provision of the West Bengal Board of Secondary Education (bracket open) appointment, confirmation, conduct and discipline of teachers and non-teaching staff (bracket close) rules 2018 এখানে আছে. It is the West Bengal Board of Secondary Education that may authorize any officer not below the rank of the sub-inspector of schools to conduct preliminary investigation against any teacher or non-teaching staff upon receipt of a complaint pertaining to the misconduct of a teacher from the committee or the administrator or head of an institution. Stop. Neither the council nor the Commissioner of School Education has any authority to conduct disciplinary proceeding, and the same is the prerogative of the West Bengal Board of Secondary Education. Step next. As it has been submitted that the council has not yet recommended any disciplinary proceeding to be initiated against the petitioner, accordingly, the instant writ petition stands disposed of with the observation that it will be open for the parties to take steps in the matter in accordance with law and not otherwise disposed. Take this judgment back. It was not required. This notification also not required. This will not be acted upon. It has not been acted upon till date. Yes.
Acted upon only 4. Only 4 times.
My lord, order was only with regard to 4, my lord, point 4.
And the others?
Well, others, well, he does not have any authority to
Any
challenge on the other
application?
side. No, my lord. My lord,
He is not challenging anything.
my lord, he
Can-
has challenged the entire notice,
I have
entire,
challenged
entire resolution,
Yes.
primarily 4-5. He is agreed
What about
only
the
with
one? You are not aggrieved. You say that the council can take steps.
any
What
supervisor.
can be done?
Who has told me that I have the authority?
Yes, my lord. But I am for the petitioner. Yes. But I am for the petitioner. But the petitioner is seeking transfer on my lord child's medical ground. But my lord, transfer application only without any prescribed form. It is the decision of the honorable petition bench that transfer application should be made in prescribed pro forma. If application made, that will be considered and disposed of. So my lord, in terms of the petition bench order, I am
The
paying only liberties.
transfer.
On liberty.
He is yet to make a formal application seeking transfer in the prescribed format. In view of the above, the instant writ petition stands disposed of with the observation that it will be open for the petitioner to file appropriate application in the prescribed format before the competent authority. In the event such application is made, the same shall be considered in accordance with the prevailing rules.
Lord, I am for the petitioner. Lord,
I'm happy to secondly go to your
litigation matter pertains to single subject teacher. Last occasion, the honorable single bench was pleased to direct Yes, my lord, this is regarding single subject teacher, but there is one submission is to be made because I prayed for quashing of one impugn order. Because, yes, my lord, just before that, my lord, it is a second round of litigation. Previously, division bench directed the school authority to take a decision that why due to single subject teacher will not be done. But my lord, I submit single subject teacher will not be a bar for me in terms of rule 6 to C and E. Because transfer application made on medical ground is exempted from the requirement of single subject teacher criteria. First, I show page 80. That is my medical ground.
Lord, I am also not opposing.
Yes.
The school authority may be directed to act in terms of 8 September 2020.
September
The
2021
amended rules. my lord.
and not the 3rd January.
No, I do not. No, I do not come under 3rd January. That is my case because I am not a single citizen.
September very.
Yes, I have annexed. I have annexed in the writ petition. I kindly see, my lord. That is at page number. Yes, 44. 44. Kindly take 6 to C and E. Who has rejected? This is the amended rule 6 to necklist 6 to C. Consider the numbers of subject teachers and roll strength. If resultant vacancy of school in particular subject becomes 0 or not in commensurate with roll strength, the authority of SMC shall not forward the applications. Now the exemption is at E. Dispensed with the provisions of clause C and D of this sub rule of application made on grounds mentioned in rule 4A to D. Now rule 4A, previous page, bottom. Medical. Self-medical. So any application made under rule 4A will not be barred by the requirement of single subject teacher in terms of 6 to E.
And show me the rejection.
Yes, my lord. Kindly come to page number 84. Who is to directly send to the DI?
Please come. The recent order dated 22nd March 2023 passed by the master of the school rejecting the petitioner's prayer for transfer on medical ground, relying on the notification.
Local arrangement does not arise in my case. That is their own memorandum.
Notification dated 3rd January
No.
2020.
No, 3rd January, they have not referred to. They only referred to their own internal memorandum.
But 22nd of July 2022
ওটা নয়।
না না ওটা দিয়েছে তো
এই নামে কোনো notification
As,
নেই।
as the petitioner was a single
No, that is
subject
66
teacher,
বলছো,
he is impugned in the instant writ petition.
কি বলছো 66 এর ওটা
Paragraph.
এই দেখো না
As per the
that is an internal memo.
As per the notification dated 8th September 2021. Application for transfer made on medical grounds is exempted from the restriction of transfer in respect of single subject teacher. Yes. It appears that the school had applied a wrong rule to reject the prayer for transfer of the petitioner. Stop. Paragraph. Learned advocate representing the commission submits that the prayer of the petitioner on medical ground will be considered. Stop. Next. In view of the above, the reasoned order, impugned reasoned order, dated 22nd March 2023 stands set aside. Stop. The head of the institution is directed to consider the prayer of the petitioner for transfer on self-medical ground. A decision shall be taken at the earliest and necessary consequential steps be taken without any further delay. Stop. Steps shall be taken within a period of 8 weeks from the date of communication of this order. Disposed.
Hello, CMOH verification is
না না এটা স্কুল করতে
First, the
CMOH verification.
medical contains self, spouse, children, everybody. Medical includes everybody.
everybody. So, my lord, CMOH verification and all.
or next stage
I have
Understand and
not
consequential, I understand, but your lordship knows what will happen.
step.
But I'll again have to come and trouble your lordship.
Next.
How much?
My lord, I am for the petitioner. My lord, petitioner is seeking
Thanks for
transfer
secondary
on
board election.
development ground. My lord, petition is 80%, my lord, definitely 11%. My lord, petitioner previously applied on transfer, but my lord, commission has illegally rejected the transfer application. That my lord, provision is, my lord, kindly see that provision. Commission has rejected that petitioner has not completed 5 years in the present school because petitioner has obtained one mutual transfer order. But my lord, rule is very specific. In case of special ground transfer, my lord, overall 5 years it shall become under the zone of consideration. So that
Show me.
yes,
medical ground
my lord, kindly see that.
distance
Yes.
ground করেনি তো
No, development. My lord, kindly.
Are you aware of this?
yes my lord in case of transfer on 4A to D my lord my lord overall service is
5
required
years.
my lord to be considered
Where is it mentioned?
Yes, my lord, it has mentioned, my lord, I have, my lord,
4A to D.
পরের
AG. My lord, it has been stated, my lord, paragraph 7, second paragraph, sub rule 1 of rule 3 substitute following sub rule, and incumbent shall be eligible for general transfer only if or he or she is confirmed in service and completed 5 years of satisfactory service in the particular school from the which he or she seeks general transfer. In this case of general transfer, next paragraph. However, for seeking transfer on the ground of mentioned clause A to D of rule 4, completion of 5 years in service in the present school shall not be applicable to the applicant who has completed overall 5 years in service. My lord, that particular.
And what is your ground?
My lord,
Disablement.
disablement. 80%
Any
disablement.
incumbent having physical disability?
Yes.
Please
my
come.
lord,
Where is the rejection?
Yes, rejection page 22. My lord, 9/11/2021.
my lord this memo is subsequent to the rejection my lord
22.
9/11/2020.
21st December
Yes.
General transfer application. It is mentioned general transfer. It does not
my lord
mention.
It's a special ground transfer. It is disablement ground. 80% disability certificate. I
Page
can.
22. See the remarks. General transfer.
No, my lord. 3. My lord, it is 3. Sorry, serial number 3. Prayer is written as dated as per present posting less than 5 years. Present posting.
present posting is less than 5 years, but your ground is physical disablement. Where is it mentioned over here?
My lord, generally, that all matter is not covered, my lord. It is
Huh?
there, my lord, it is true, my lord. I have annexed that document, my lord, page 19, my lord.
No, was your application
Yes, yes.
disclosed? Did your
Yes,
application?
yes, I have stated in my REIT application also. I have
Not
stated
your
in my
state.
My lord, prior to that, my lord. My lord, if your lordships kindly turns to page 22,
Hmm.
our date of rejection is, my lord, 9th of November
I've seen
2024. This memo is subsequent to the date of rejection.
Yes.
So, my lord, liberty may be given to the petitioner to approach.
12, 11, 21, and this is December 21. Acha. The petitioner seeks transfer on the ground of his physical disability.
Yes.
Stop. His application for transfer made in August 2021 stood rejected
Yes, yes.
as he failed to complete 5 years of service at his present place of posting. ঠিক আছে? The petitioner refers to the amendment made in the transfer rules published by the School Education Department on 21st December 2021, which exempts teachers with physical disability to have completed overall 5 years of service at the present school. Stop paragraph. It appears that the rejection of the prayer of the petitioner was earlier to the amendment made in the transfer rules. Stop. Next, in view of the above, leave is granted to the petitioner to apply afresh. Stop. The head of the institution shall consider the application of the petitioner in terms of the prevailing rules at the earliest, but positively within a period of 8 weeks from the date of making the application. Stop. All consequential steps shall be taken in the matter in accordance with law without any further delay.
By the my lord, kindly mention respondent authorities. That will cover.
Authorities.
Yes, that will cover. Great.
What is this bunch?
Well, it is the inter-transfer rule.
All transfer
all
rules.
Inter-compilation.
Myself.
Yes, yes, it is inter-compilation is there up to date.
Thank you.
Great.
আচ্ছা শুনুন না, 1:27 তো বাজে। At 2 o'clock I come back.
Please transfer back. Very good.
বলুন। Is anybody present? Dismissed.
Item number 170.
Hello, I'm for the petitioner. This is regarding transfer. She's a single mother and divorcee, which is a special ground under Rule 4. My lord, I made application. I should be candid before your lordship. My application has been sent through the TIC to the president. That is at page number 86 onwards, and nothing has happened afterwards. So I'm paying consideration by the school authorities to take a decision.
Where is your application in the prescribed format?
It was previously. After that, Tanushree Karmakar came into effect.
So then right now you are to apply a
Yes, yes, very well, my lord. If your lordship so desires, I will make it in prescribed pro forma.
come.
Because at that point of time, Tanushree Karmakar was not there. The judgment, division. bench.
Petitioner seeks transfer on special ground. Stop. It appears that her application for transfer is a pretty old one. Stop. Next. In view of the above, the instant writ petition stands disposed of by observing that it will be open for the petitioner to make fresh application for transfer in the prescribed format. Stop. In the event such an application is made, the same shall be considered by the head of the institution in accordance with the prevailing guidelines, not guidelines, rules. At the earliest, but positively within a period of 8 weeks from the date of communication, from the date of filing the application. That's all necessary consequential steps shall be taken thereafter without any further delay. Disposed.
Grateful, your lordship.
Grateful.
Amar,
Yes.
my lord, kindly come to page 31. That is the status. I was withheld on the ground of single subject teacher. So, my lord, first of all, my lord, this single subject teacher cannot be barred in terms of the 3rd January 2022 notifications. And secondly, my contention is that there are 29 students and 5 teachers. It's a junior high.
29 students and 5. What does the teachers do? Go and gossip? Huh?
So that
Maybe
is why petitioner
classes
wanted.
jointly.
Maybe that is gossiping.
Gossiping. Allow me the students. There's a healthy environment in the school then. So, my lord, in that case, my lord, I cannot be withheld on this ground. And I may be allowed. So, my lord, 3rd January notification comes into play in my rescue. Yes. And this post of bioscience is an additional post.
And the court's order is also there.
Yes. Lordship is in consideration.
ডিভো আমাদের সিঙ্গেল টি সাবজেক্ট টিচারের যে অর্ডারটা আছে সেটাই করে দেবেন দিস উইল সাফাইস
Yet Amitabh Paler referenced. আমি দিয়ে দেবো কপি দিয়ে দেবো Amitabh Pal.
নেক্সট ডিসপোজড
171.
I'm for secondary board, your lordship.
My lord, kindly come to page number 35.
35.
35, kindly take the left.
Status.
Yes, this is the status.
Hard copy verified and
on medical ground.
Higher consideration.
Yes. Kindly come to page 37.
Yes.
Medical verification was conducted.
Yes.
180. Your lordship has seen medical verification. And since then it is pending, my lord, the authorities.
What about the medical report? Has it was date was fixed?
Yes, it
for
was conducted.
The medical test, but thereafter?
Thereafter, since the portal got under suspension, no step was subsequently taken. So I am praying for.
What was the medical fitness of the teacher checked up?
Yes, paragraph 9 of my writ petition.
Please come.
Paragraph 9 of my writ petition.
Petitioner's prayer for transfer on medical ground.
Self-medical.
Self-medical ground was forwarded by the head of the institution to the district inspector of schools. Stop. 22nd September 2022. was the date for medical verification. As communicated by the Chief Medical Officer of Health Malda, stop. The petitioner is not aware of the fate of the medical verification, medical verification, and the fate of his application. Stop. Next paragraph. DIS stage pending.
কি ওয়াইফের নাকি
Medical conducted. Very well disposed.
My lord, I am sorry, my lord, it will not be self, spouse medical.
Spouse medical ground.
Yes, miss, I'm sorry, my lord.
They can self.
Not self.
Mentioning self, spouse, children becomes difficult. If medical ground is in one sweep, then all will be
Separate.
covered.
Yes.
180. Oh, হয়ে গেল 180. 189.
May it please your lordship. Now for the petition. This is my application for transfer and it has been rejected by the DI on the ground of single teacher. But against that, my lord, I have come before this honorable court.
Date.
Just request your lordship, my lord, to see the rejection. Your lordship will find at page number, my lord, the date of rejection. Your lordship will see 5th of October 2021. So the district inspector, my lord, rejects it and gives it back to the head of the institution.
But that point of time,
Properly rejected, HY is requested to hold the application single subject teacher until arrangement substitution.
But
page.
P annexure P2.
But I'm sorry, my lord, the proper pagination one has not been done.
My lord, it should be, my lord, 17, 18, 19, 20.
21,
21.
21.
Yes.
His application has been
Yes.
withdrawn.
So they have to be instructed
serial
to
number
hold
2.
your application. You have to hold. So your
Yes.
application for transfer has been kept on hold.
And my lord, HY also.
No, I tell your lordship, this has been returned by the district inspector to the head of the institution by saying that keep it hold.
Right.
Do
That
not
means
apply the alternative arrangement rule. So which is not right.
alternative arrangement
My lord,
rule was
because
there.
It was there, my lord, 22nd September's rule. If I request your lordship, my lord, to see.
Please come.
My lord, that has been
application
said, my
filed
lord.
by the,
Till the, my lord, single subject teacher in the arrangement or substitution.
for transfer.
The application.
For transfer. Made by the petitioner has been directed to be kept on hold by the district inspector of schools
My lord.
to the head of the institution on the ground that the petitioner is a single subject teacher. ঠিক আছে? Single subject teacher যে অর্ডারটা আছে সেটা দিয়ে দেবেন। Disposed.
Great. By the affidavit of service cannot be taken on.
Yes, taken on record.
But,
09.
I am for the petitioner, my lord, must candidly, my lord, say before your lordship, this is not a transfer matter. This is, my lord, with a prayer, my lord, for obtaining BEd, B.Ed degree to the school.
Will it be treated?
Yes, my lord.
It will go
has
back
been
to the
wrongly-
same place.
Same place, yes, ma'am. Great.
209. কোনো অর্ডার হবে না মোবাইল লিস্টে যেরকম জায়গায়
না 209 হলো না তো চলে গেল
241.
241, I am for the commission.
My lord, page 90. All formalities have been completed.
মোবাইল লিস্টে যে জায়গায় ছিল সেই জায়গাতেই থাকবে।
All formality, page 90. All formalities have been completed. Self-medical ground, it is pending at the end of the commission.
90.
Page 90.
There are only 89 pages.
No, there is a status, my lord. Kindly see the status.
Status is 89.
I'm sorry, my lord. In my copy, it's pending at the end of the commission. It is to be decided by the commission. That's all.
DIWBSCC. Is October 2022.
No, everything has been completed. Now it is pending since the
These
paperwork
cases, your
under
lordship directed the
suspension.
commission to take a fresh, my lord, medical verification and then
Medical
consider.
verification is completed.
No,
That's
it
why
is
has
in
got
2021.
Maybe, but it has been completed and went to
Then medical
commission.
condition has to be, my lord, ascertained.
আচ্ছা, করুন।
Review
বললে করুন।
That was the order, my lord.
pending at the end of the commission. Disposed.
Please post no, huh?
Full service commission. It is medical ground, self medical. Vote 2. আচ্ছা এফিডেভিট অফ সার্ভিস বিল দেখবেন সব কটা কিন্তু করে দিচ্ছি
242.
I'm for the petition. Kindly come to page 77. I'm sorry. Status. School can reject করেছে? Oh, no reason has been stated.
You are not eligible for
You are not eligible as per
No reason
present
stated.
criteria.
general transfer.
There is a notification. Kindly come to the notification dated page 52. They have to give a reason as per the notification.
Unreasoned order.
Unreasoned order. Nothing. Page 52 for your lordship's convenience, my lord.
Well, the previous one, that is the reason you are not eligible. No, no. Why he is
Bro,
not
what?
eligible? That
Why
is to
eligible?
that is twist.
Page 52 is the notification.
The petitioner's application seeking transfer. Why not eligible? Stood rejected by the head of the institution, mentioning that he or he is not eligible for the same. As per general transfer rules, 2015. Stop. The specific reason disclosing the ineligibility of the petitioner for being transferred has not been disclosed. Stop. The unreasoned order of the head of the institution cannot satisfy the test of reasonableness and the principle of natural justice. Stop. Next, in view of the above, the rejection of the petitioner's prayer for transfer is set aside. Stop. The head of the institution is directed to reconsider the application afresh in accordance with the prevailing rules for transfer at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Necessary consequential steps shall be taken by the head of the institution in accordance with law. Next.
Grateful to lordship, much obliged. 43.
এটা আমাদের আছে 243 244.
Yes.
My lord, kindly come to page 89. This is on single subject teacher, it has been withheld, but
My copy is completely illegible.
Number of total teacher respect to the above mentioned academic section.
Total teacher in respect with
As
the above
per
mentioned academic
particular school 1, that is single teacher.
single subject teacher, it has been withheld, but it cannot be, my lord.
Very well, single subject teacher. The petitioner's prayer for transfer has been rejected on the ground of being a single subject teacher. ঠিক আছে, যে অর্ডার আছে সেটা করে দেবেন। Disposed.
Grateful to lord.
Grateful. Malam for the commission.
I am for secondary board.
244 my lord, Mohammed
বাবু সার্ভিস গুলো দেখে নেবেন। Yes.
Mohammed Hafiz appearing for the state my lord.
My lord, I'm covered by the three lordship's order. 2 concept willing teacher, Rupak Dhua's judgment by the present coordinate division bench. Then your lordship's order, my lord, kindly come to page number 91. This is the third round of litigation. First, my lord, on single subject teacher, single bench was pleased to dismiss the writ petition. Division bench set aside the order, directed to follow the appropriate rules and to conduct the process. Now, my lord, what they have done, kindly come to page 91. They have written to the schools and they kindly take the middle paragraph, the 4th line onwards. You are hereby requested to inform as to whether a willing teacher of history. Now, the Rupak Dhua's judgment has clarified it. My lord, willing teacher cannot be read into the 3rd January notification. This is the judgment. Page 5, last paragraph, Rupak Dhua. Now after and তুমি সব জানো দাদা।
না না আমি জানি।
Now my lord, this willing teacher concept is no longer a concept in the notification.
So
Now my
this is a single teacher.
and your lordship's judgment এই অমিতাভ পাল এটা দিয়ে দিলাম। এটা single teacher is my lord's judgment এটা।
দেখি একটু।
That observation lordship has made that this non-finding of another teacher will be no ground to withhold the single subject teacher transfer, irrespective of the fact and the resultant vacancy. That
Yes, same order.
and that order, my lord, this willing teacher also.
All right, take this. Rupak Dhua has been
Rupak Dhua has been quoted.
ওখানে আমাদের যেটা আছে সেটাই করে দেবেন। Yes, disposed.
আমার দাদা আগে একটা সেকেন্ড 244 এর এফিডেভিট এটা কত মনোজিতটা কত 244 yes 244 টা হয়ে গেল তো 44 টা হয়ে গেছে হ্যাঁ
245.
245, I am for the commission, my lord.
I'm for secondary board, your lordship.
Yes.
এটা একটু নিয়ে
Which stage?
page 91, my lord.
Back to
My
the
lord, may I
application.
just-
The applicant has resumed
may I just come back tomorrow?
from the respected such and such.
No, it's a medical ground transfer on the wife's ground.
Huh.
Where on the same medical ground, wife got transfer, but it has been held that no, he is not eligible on the same medical ground at the same time.
Then he has to apply afresh.
No, why afresh? My lord, the ground has to be considered. On the same medical ground, wife has been allowed. At the same time, husband applies on wife's medical ground. He has
Husband and wife suffering from same disease.
no, my lord. Wife's gynecological problem.
All right.
Wife got transfer,
All right.
showing that husband is also entitled. Wife, spouse, child, and self. Now the husband's application has been returned on that ground.
No. The same medical ground for one person, two transfer can be made.
Yes, there is no bar in the law.
If
Oh.
the wife is transferred,
Yes.
then the husband will stay back.
No, my lord, he has to apply afresh stating the fact.
Applicant,
Right,
as
yes,
the
paragraph
application
9.
has been,
Paragraph 9 of
as
the
the application has been resumed. What is it? Oh, returned from the DI.
return.
Why? As per
Double pin
report
pitch.
of medical
কোথায় বার আছে?
exception, no significant. No, it mentions that no significant abnormality
Yes,
has been.
that is my case. On the wife's similar ground, she has been allowed transfer. Now it writes that it is no significant ground.
No, possibly you are not proper.
So, my lord, may I come back
It's
tomorrow?
from 22. When did the wife get transferred?
Yes, I have stated my document of the
No abnormality found
Yes.
about her physical and mental condition.
But she has
This
been allowed on
application
that
was
same
found-
ground.
Let's see, allowing the application for transfer.
This application was found on the spouse medical ground.
Kindly come to page 27, my lord.
No, পড়া যাচ্ছে।
পড়া যাচ্ছে। It is the certificate obtained by the school authority.
We don't know that after treatment whether she is, my lord.
Where is the order of transfer of the wife?
Paragraph 9 I have stated.
No,
But
no.
may I come back tomorrow? May I come back tomorrow? May I come back tomorrow? Better I'll be better instructed on this ground.
Retain its position in the combined list. Next. যেটা যে জায়গায় ছিল সেখানেই। 251.
My lord, kindly come to page 70.
I'm for secondary board.
Oh, achha. Page 77, my lord.
Page 77.
Single subject teacher. It is on.
A rejection is of my lord 2022, my lord.
Single subject is still a single subject teacher. And my lord, a very unfortunate case. School
In the
itself
meantime, my lord.
School has given the NOC at page number, just the previous page, my lord, page 76. School.
Anyway, single subject teacher, same order passed, disposed. Next.
Single teacher.
The key ground, key ground.
Single teacher.
Kindly come to page 78.
78.
78 remarks, single subject teacher.
Rejected by school.
দেখেছো তো কি গ্রাউন্ডটা পরেরগুলো দেখে
প্যারা 5 দেখো।
Single subject teacher disposed. Service is on record.
জেনারেল তো এসএসসি পেন্ডিং কাইন্ডলি কাম টু পেজ 98 এটা কত এটা কত
এই 267
My lord, kindly come to page 98. Everything is completed. It is pending at the end of the commission. Commission is to take a decision. It is on spouse medical ground. It has been forwarded to commission.
উপরেরটা
এটা দেখেছি, এটা তো আছে।
Commission.
Commission is to decide.
And within 8 weeks.
Yes.
268.
No, not to be.
My lord, I'm for the petitioner.
Also, 268.
দেখি কি 260 কে দেখলে 67 নিয়েছো?
No.
What is the stage?
My lord, it is not similar. Kindly come to page 88.
All right.
Page 80 is the impugned order. I'm placing before lordship. There were previous rounds of litigation. He was withheld on the ground of single subject teacher. Order at page 86 by my lord Justice Mantha's order is there. Then my lord, commission has decided, kindly place paragraph 88. With reference to the above, I am directed to inform you that your transfer application as forwarded from the DI Nodia has been checked by the West Bengal Central School Service Commission, and it is found that your rank is presently at second position in your first preferred school, third position in your second preferred school, and first position in your third preferred school. However, it appears from the portal that your third preferred school, namely Agorpada Savitri Mahajati Balika Vidyapith, has total enrollment of
Yes, the teacher-student ratio you are not matching, right? So third goes. So one
third
and
post.
two
Now
remains.
I have only one submission to make. My lord, many people can make application for transfer before the it was put under suspension. It is pending. Now my submission, respectful before your lordship, is that merely because making an application will not debar me from being considered when I have approached, I have pursued my case of transfer. I may be at the second position in my application. Merely
Since you have approached the court, you should be given preference.
I have come because there is no provision.
Preferential treatment.
No. There is no provision for reserving a post merely because I have applied for it.
Yes.
Now
But
they
then,
have-
1 minute. This is more than 2 years back.
Yes.
What is the position now?
Well, that is how.
You have taken a final decision.
Oh,
Well,
in August, June.
If Malad more than one candidate applies for a single post, Malad commission determines the inter se merits of the candidate applied for transfer, Malad according to inter se merit, petitioner in the writ petition is not coming within the zone of
I
consideration.
understand.
No, that
he
is not the case.
Second position and he is in the
They
first, second position.
My lord-
In both the schools,
Yes, merely
second position.
Second
there is
position.
no
So, Malad,
there
The first position.
then Malad kindly direct me to take instruction,
Yes,
Malad.
please
very well.
take instruction.
Well, only one submission. My learned friend has said that there is a determination. There is no determination. It says only application pending.
The
They never say that I'm not eligible.
rejection of the petitioner's prayer for transfer by the commission on 21st June 23 is impugned herein. Stop. Paragraph.
Copy the
The advocate for the commission is directed to revert instruction with regard to the status of the first preferred candidates in respect of the two preferred schools mentioned in the impugned order of rejection. Released 3rd of December. Service is taken on record.
Well, I'm for the petitioner. Kindly come to page 76. Single subject teacher. Well, this is also in regard with single subject teacher. Kindly see the third serial number. DI writes to the head of the
We're in
institution.
same category. Yes, this was single subject teacher.
3rd January notification. আরে এই তো 3rd January notification.
আর একটা আছে মোম মন্ডলটা কত হতো?
This was
আমি I am for the commission.
আচ্ছা এই আগেরটা আগেরটা আগে
এটা বোধহয় এসএসসি পিকটা দাও।
কি দেখি তুমি তো অর্ডারটা ছিল। হ্যাঁ
It is pending before the School Service Commission. Let there be a direction upon the commission to consider.
commission.
কি গ্রাউন্ডে সেটা বলে দিই দাঁড়াও। মোম মন্ডল তো নিজেই ভদ্রমহিলা।
A single subject teacher ই ছিল, সেই যে কারণে রিজেক্টেড হয়েছিল। Anyway,
দাদা কি গ্রাউন্ডে দেখি?
commission
Yes.
কিছু দেওয়ার দরকার নেই, ট্রান্সফার।
Yes, pending at the end of the commission.
কত
Service কত?
277
278 করা হয়।
70.
I'm applying for the statement.
Here the petitioner's transfer application on her medical ground has been verified by the CMOH and forwarded back to the district inspector. Thereafter, it is kept pending at the end of the district inspector.
All right, state.
Yes, madam, I am.
What is your instruction?
Well, my instruction is suspension of 3 portal is extended time to time, madam. And
Again into DI. Medical over.
Great.
Disposed.
I'm for the petition. 8 to 3. Imran. 9. My lord, kindly come to page 102.
Service.
I have handed over. Hey, কোথায় গেল? Commission pending. 102. 39, sorry. Oh, yeah.
Yes,
Page 102. My lord, is pending at the end of the commission. Commission is to take a decision. It is on this child's medical ground. এই তো commission pending আছে. Commission is to take a decision.
39
Right. The difference. এটা কি আছে? 39 এটা কিছু দেখলে না? আচ্ছা other details.
Commission will take a decision. Disposed.
Within 8 weeks, madam. 8 weeks. Yes. কি লিখেছিস?
সবুজ এটা বার করে ইমপিউন অর্ডারটা বার করো। Come to page 94. It is pending at the end of the commission, general transfer application. Page 94.
General transfer commission. Disposed.
Order bar করছো কেন? Well, this case is a bit different because this is a second round of litigation. Commission took a decision. I straight away, yes, my lord. I straight away draw your lordship's attention to the last order, page 107 by the coordinate bench. There was a direction to consider my transfer application, but that was not allowed. Page 110. First.
Yes.
My lord, kindly see, your lordship will find that reflection. You have applied for transfer with 3 preferred schools, namely such and such. It appears from the email reply dated such and such received from the concerned school authorities of the first and second preferred schools. Effectively, the said school has no vacancy in subject Sanskrit normal section, medium Bengali, no vacancies seen in the portal for your 3rd preferred school. No problem with that.
That means there is no vacancy, in any
my
of
lord.
the schools.
Yes, ma'am. Then I do not agitate this issue. That is my submission in the previous case also. If there is no vacancy, no problem. But when there is a vacancy, why will you not allow me when someone else has made an application?
Yes.
Now, my lord, then my lord, I made another application. Kindly come to page 112. That is a similar. Then, my lord, I preferred an application in prescribed pro format, page 113. Giving fresh applications of the schools. I'm sorry, fresh options of the schools.
This is pending.
It is pending.
There are how many times can you
There is no bar.
Danger option.
There is no
There's
bar.
no bar. You
There is
can
no bar.
doing it.
I can.
Distance between this. What is the ground of your transfer?
This is my lord. This is general.
Transfer.
I have written my lord. Kindly see page 116. He is eligible for
Present
transfer.
this distance between the present school and permanent address. It is only 28.
No, 35 kilometers.
The route distance and the radial distance is 28.24.
Yes. The bar is for general transfer. The school and the intended school distance has to be more than 25 kilometers. So I want to go to a further distance. No, it's a general transfer. Page 116.
General transfer কোথায় কি option দিতে?
আরে এটা offline application দাদা. Now kindly come to page 124. The school has given NOC. Page 124.
No, school initially also gave NOCC.
Yes.
How many times can this be considered?
My lord, in case of medical ground, my lord, he
Not medical.
need-
This is
no,
general.
then my lord, the
Distance.
option if he chooses, my lord,
Distance ground, 3 schools.
then my lord,
chosen,
3
then
preferred school,
vacancy.
only those 3 preferred school, no more chance.
No
No.
As per my
No, no. May I clarify, my lord? My lord, that was
check up your rules.
no. May I? My lord, that was online application. That was not allowed because there was no vacancy. Now, rule nowhere says that you can make application only once. No, if vacancies are not there, that is not my fault. So
No,
I
if
can
he has
apply.
made a fresh application, there is no bar.
Fresh application.
He submitted that I submitted the new vacancy.
No. Fresh
That is not-
application.
Made fresh
Fresh
application.
application, no bar.
Considered.
No, but then he can go on making.
Yes.
Yes, unless I'm getting at school, I
Yes.
can. The rule permits so. School has also given NOC.
The petitioner's initial application for transfer on distance ground was considered and no vacancy could be found in any of the 3 schools preferred by the petitioner. The petitioner has filed application afresh.
Offline application.
Offline application afresh for consideration of his prayer for transfer.
14 July, I made the application.
In the prescribed format. Stop. The same is pending consideration. Head of the institution will consider.
No, school has forwarded, my lord. Page
When?
126.
126.
Yes, 126. Forwarding here with the letter dated such and such. General transfer as he is eligible for that because of this.
District inspector.
DI will consider. Tarapur, not a
DI. Disposed.
Wait. 41. এটা কত হচ্ছে? I'm for the petition, my lord. My lord,
42 my lord, I am for the
I
commission.
have come
I am for the
on behalf of this
করুন আগে করার।
assistant teacher who is a father of a 75% disabled son suffering from autism and mental retardation. 75%. May I just submit? 75%. I've made application at page 101. Previously, my lord, my application was not considered because it was not in a prescribed pro forma. Page 102 is my prescribed pro forma dated 17 July 2025.
School considered?
No, school has not yet considered, my lord. Kindly later.
Please come.
I have to deal with sympathetically. 75% disabled autism.
75%
Page 101.
disability of the child.
No, he's not a child. He's an adult.
For medical
now.
test.
All right.
This is more vulnerable.
Disability of the son.
Son.
Special ground. Transfer on special ground.
কিসের?
Yes, sir.
না আমি কমিশন।
Oh, that I did not know.
Transfer on special.
Yes, DI has to send to the concerned CMH
ঠিক আছে?
for further medical test.
It is pending at the end of this school.
Oh, then CMH will conduct a medical one.
Yes. School authority will consider.
That instruction I did not have because I did not know.
School has forwarded.
No. School forward EIS has no power to interfere the offline application. That is
Dispose. School.
এই বছর পাঠিয়ে দিয়েছে CMH কে?
না পাঠাতে হবে যেটা আমাদের কনসিডার করতে হবে
43 my lord, I am for the commission.
Stage
My lord, kindly come to page 101, fresh application. Because there was a previous court order where my application was directed to be considered by the coordinate bench. That is at page 97. It was considered at page 100 as there is no vacancy. I made fresh application in the prescribed.
Which one was the earlier one? Same order passed?
Page page 97. Page 97.
Which is
Oh,
the
acha.
earlier matter? 41?
Sabyasachi,
Sabyasachi is 41.
Sabyasachi 41.
What, same as 41?
41. General transfer.
Fresh application.
20.
Head of the institution will consider. It is
My lord,
same
school
as
has
41.
just my lord, school has given NOC and kindly, my lord, school has forwarded to DI, page 117.
So it is right
DI
now
is
at
to
the DI stage?
Yes, DI will consider.
DI will consider.
Purulia, DI SC Purulia, page 117.
All right, disposed.
This is my application for transfer, my lord, offline, made on, my lord, special ground, medical ground. So, my lord,
Medical ground?
yes, madam. That application, your lordship will find at page number 22.
Whose medical ground?
Spouse, my wife's.
House medical ground.
So, my lord, that application is made offline in format on 21st of April 2025. So, my lord, even in spite of, my lord, it has been received to the school. School did not take any difference.
All right, school.
Medical ground application, madam.
Yes.
Yeah, affidavit.
Disposed.
Affidavit of sales.
My lord, item number 45, I am for the petitioner.
My lord, I am for the state, my lord.
My lord, this is the matter regarding transfer, my lord, and this is under, my lord, distance ground. The application was preferred, my lord.
Which stage is it pending?
Lord, it is, the school has not yet forwarded my application.
Age of the head of
Your
the
lordship
institution.
kindly passes this order.
Same order?
Yes. Pending before the school authority.
Yes. Disposed. School. School আছে দরকার নেই এটা কি ground. And this ground level order. Yes, next.
46. 46.
Same order করে দেবেন. Model
Lord, 46, my lord, I am for the petitioner. This is also similar matter, my lord. This is also pending before the school authority, my lord.
All right.
My lord,
School.
affidavit of service and your lordship.
Yes. দেখি কি order দিচ্ছে? দেখি দিন ভেতরে.
School a pending.
Yes. Disposed.
I'm grateful to lord.
চেষ্টা দিয়ে দিচ্ছি আমি
Great.
No, 45. Order is there inside.
45 থাকবে
Yes.
Petitioner might not matter relates to high matras education matter. Wrongly.
Release for want of determination.
একটু নিয়ে নেবেন এটা একটু নিয়ে নেবেন
Matter relates to high madrasa.
for the CPF to GPF lordship. Your lordship's order.
Will it be the employee himself?
Yes, lordship.
And the dates are proper?
Yes, lordship. I have correct.
All right, same order disposed. Order is there inside. Next.
CPF to GPF area. CPF to GPF area fence. The petitioner himself.
Same order disposed.
CPF to GPF manner, the petitioner himself.
Same order disposed.
I am for the statement.
Disposed.
Grateful.
Same order.
I'm for the petitioner.
I am for this statement.
CPF to GPF, your lordship's order.
Disposed.
But I am for the statement.
Petitioner is the son of the deceased teacher.
What about your mother
My mother was predeceased, madam.
and sister, brother?
Oh, madam. He is the only legal heirs, my lord. The nominee was there, my lord, the TPO.
Disposed with the corrections. Next.
You have, my lord, I am for the petitioner. The matters relates to, my lord, overdrawal. Petitioner retired on, my lord, 31st August 2024. And my lord, after retirement, and one amount was calculated that he has to deposit. My lord, I have corrected your lordship's order. 2,68,000 on amount of overdrawal, alleged overdrawal.
Disposed with the corrections.
Great. '56 also, my lord, overdrawal. 56 also, my lord, alleged overdrawal amount. My lord, petitioner is the widow of the deceased teacher who, my lord, died in Harness on 23rd December 2022. My lord, I have certain corrections has been made. Subject to your lordships.
Hmm.
Petitioner deposited the amount on 9th October 2024 and pension payment order issued 29 January 2024.
All right, disposed with the corrections.
Great. The 57. Boita de. 57, my lord, I am for the petitioner. Petitioner is the son of the, my lord, deceased teacher who was physically handicapped. Petitioner, my lord, relied on a circular.
Deceased means after superannuation?
No, my lord, died in harness.
Died in harness?
Yes, that excellent. Well, no, my lord, after retired in 1987 and expired on 27 February 2012. Petitioner mother expired on 10th December 2007. Now, my lord, petitioner is praying of, my lord, physically handicapped family pension. Petitioner relied on a circular. This is the, my lord, circular on, my lord, 5th September 2005. My lord, let it be considered by the DI. My lord.
Where is your application?
My lord, application.
Dekhi.
Application is page 17, annexure P4. 5th September 2005. Bottom portion.
Please come. The petitioner claims to be a physically handicapped son of a deceased school teacher. Stop. He prays for grant of family pension in terms of the government memorandum number. Dated 5th September 2005. P25-SC within bracket caps P slash caps IM hyphen 43 slash 2003. Dated 5th September 2005. Paragraph, the application made by the petitioner seeking pension, family pension, is pending consideration at the end of the District Inspector of Schools, Secondary Education, Tomluk.
Secondary education, Purva Mednipur.
Tomluk, Purva Mednipur. Without entering into the merit of the same, the instant writ petition is disposed of by directing the District Inspector of Schools to consider the application of the petitioner strictly in terms of the memorandum referred to herein above, at the earliest, but positively within a period of 8 weeks from the date of communication of this order. It will be open for the aforesaid respondent to check the medical documents of the petitioner to come to a finding, to come to a final conclusion. Stop. Paragraph A. Paragraph A. All consequential steps. Now, if the prayer of the petitioner is allowed, the necessary consequential steps shall be taken by the authority without any further delay. Stop. Learned advocate for the petitioner is directed to forward a copy of the application seeking family pension, the medical documents in support of such claim, and to the aforesaid respondent at the time of communicating the order of the court. Disposed. Okay. Take the book back.
I am for the petition. Matter is just to overdrawn of amount 2,73,618. Assistant teacher, petitioner was an assistant teacher, and CR Chalan is at page 18, my lord.
All right, disposed. Order আছে ভেতরে।
My lord, in this matter, I have carried the Honorable Justice Bharadwaj's orders.
What is it?
Same, my lord, overdrawn amount of 1,22,434. TR challenge is at page 15, my lord. Petitioner himself.
Where is the challan?
Page
15 is the PPO.
PPO.
Challan is not here.
Lordship, in PPO, the kindly see, Lordship, deduction due to salary overdrawn. It has been recorded.
Yes.
1,22,434.
When did you deposit this?
Deposited on
The challan should be here. Where is it?
my lord, in PPO it has been recorded.
Oh, what? But then your date of deposit? You must be having copy.
Right now, I don't have any copy.
I'll adjourn it. You come back with the copy?
Yes, sir.
The petitioner seeks for refund of the overdrawn amount. Stop. Leave is granted to the petitioner to file supplementary affidavit. Annexing document to show that the alleged overdrawn amount was returned deposited in the office of the treasury officer. Released on 8th December.
My lord.
এটা ফেরত দিয়ে দেবেন, এটা দরকার নেই। Service is taken on record.
And for the petitioner.
60.
Overdrawn. Your lordship's order, lordship. Challan is at page 18. For an amount of 2,83,790.
Disposed.
Much.
This is also overdrawn. Treasury challan is at page 17, my lord. I have corrected your lordship.
Which?
Disposed.
Grateful one. Yes. আমারটা নেই।
I am for the petitioner.
I am appealing for the statement.
This is my lord. My lord, here the commission has confused between the eligibility criteria to participate in the teachers eligibility test and
participate in the recruitment process. Recruitment process.
All
This
right.
is first SLST in respect of my lord, these special educators. This is not that SLST after that 16,000. Kindly comes to page 66. I'll be drawing your lordship's kind attention to the guidelines of the TATE, and thereafter I'll draw your lordship's attention to the, my lord, the action of the commission. Page 66 is the guidelines of the state
Yes.
of TATE. Page 67 are the guidelines. The relevant clause is 5.2 at page 67.
Yes.
5 is following persons can be eligible for appearing in the TATE. 1, I leave, it is not relevant for my case. 2, a person who is pursuing any of the teachers' education courses recognized by the NCT or RCI. In this case, RCI is relevant, Rehabilitation Council of India, as the case may be, specified in NC notification dated such and so. So, person who is pursuing is eligible to participate. Now, my lord, this dispute went up to the Honorable Supreme Court. Kindly comes to page 72. My lord, kindly sees, I have the judgment if your lordship wants, but this will suffice, my lord. That is why I am not troubling your lordship. This is, my lord, after the Supreme Court's, my lord, determination. I am directed to refer to your letter dated such and such on the
What
subject.
is the issue right now? Tell
Issue is that they have, my lord, kindly comes to the issue. This is, my lord, how it was interpreted that pursuing candidates can participate. Now, kindly comes to page 76. 76. 76, my lord.
76.
Yes. Kindly sees, this is the notification where pursuant to which I want to participate, or I want modification of this notification in REM to save this recruitment process, basically. Teachers eligibility test 2025 and first SLST for recruitment of special education teachers in government aided at such and such. Now, in doing so, they are following, kindly comes to the last line. The recruitment process will be governed by the West Bengal School Service Commission recruitment for persons for appointment to the post of special educated teachers rules 2024. I'll be drawing your lordship's kind attention to that. Now, kindly see what error they have done.
Where is the advertisement?
Yes, this is the notification.
This is the advertisement.
Yes. Now, my lord, kindly comes to page 81, the eligibility criteria.
Yes.
Now, this eligibility criteria is for persons who are possessing the, my lord, the qualification for recruitment. Educational qualification, including professional qualification for selection of special educators is such and such. Special education, minimum qualification for the post shall be B.Ed in special education from RCI approved institution and possessing a valid RCI Sierra number. So this is, my lord, the eligibility criteria for being recruited. This now the commission has considered this to be the eligibility criteria for participating in the TATE examination. So that is why.
Where is the TET?
First page, page 76. It is TATE. Yes.
Page 76 is the recruitment notification.
Well, that is a TATE. Kindly see. Teachers eligibility test 2025 and first SLST. So teachers eligibility test and first SLST. TATE and thereafter recruitment combined. Now, my lord, kindly, may I just, it will be appearing from the, my lord, from the my lord, previous page also that is there. Kindly comes to previous page. This is the notice. Teachers eligibility test 2025 first SLST for recruitment of such and such in compliance with the direction by the Honorable Supreme Court. In another matter, the West Bengal Central School Commission will hold TATE 2025 for recruitment of special education teachers in the government aided stroke sponsor schools. Now kindly comes to the recruitment rules itself. 2024 recruitment rules, page 86. The recruitment rules provides for Minimum eligibility criteria, page 87, that is for recruitment to the post. Candidates must be a citizen. I'm leaving. Minimum qualification for the post shall be B.Ed in special education from RCI approved institution and post. This is what they have copied and pasted in the notification. Now also kindly comes to next page, page 88, point number 11. Conducting of teachers eligible. Lordship is there, point number 11. Conducting of TET within bracket teacher eligibility test and selection candidates and preparation of panel for special educators for such and such, such and such. My lord, 1, 2, 3 kindly comes to 3. West Bengal Central School Service Commission shall conduct TET for special educators following the NCTE norms. The norms that I have pointed to your lordship, which says that pursuing can also participate. Now, a point will be taken by the commission that we are belated by 1 month. The time for participating in the process has expired, and thereafter I have come with a prayer to participate. But my humble submission is that I am also having a prayer for modification of the notification itself. This will be saving the
But
notification.
then why did you not come within the date when the application?
I tried to, my lord, go into the computer and do everything, but still we couldn't come. But point is that even if we do not come, my lord, as of today, my challenge will be germane in view of the fact that this vitiating factor in the notification itself will remain, and thereafter of the recruitment process, subsequently when the recruitment process proceeds, my lord, this will be pointed out. And here, my lord, what happened, my lord, kindly sees the date has not yet been notified. The only place kindly comes to page 85. This is the tentative schedule. Commencement of the online application already commenced on such and such. Last date of receiving such and such expired. However, payment would be made up to such and such. Written test to be notified later. This notification has not yet come.
Your application is not on record.
I could not apply because I am not. I will not be allowed to apply it in view of the fact that I don't have RCI, the minimum qualification for being recruited. But I am pursuing the RCI recognized special educators course, which will be, I have annexed all documents. So I cannot participate in the TET. So if I cannot participate in the TET, I will not be able to participate in the recruitment process. But what they have heard is that they have confused themselves in respect of the eligibility criteria required for recruitment vis-a-vis the eligibility criteria. But kindly comes, my lord, how the Supreme Court has, my lord, clarified. Kindly, it is the NCT circular itself. I have the judgment also. Kindly comes to page 72.
But then whether I'll enter into it or not is.
Well, this my prayer is for modification. That you and this is order 1 rule 8 is there. Persons cannot be, my lord, restricted to participate expressly because an error committed by the commission. The commission proceeds on non-application of mine. Kindly comes to page 72 once how Supreme Court has dealt with. Kindly sees, my lord.
No,
This
but
pursuing
yes.
point, my lord. 70. May I just place it, my lord?
Submission is that
Paragraph
the
83.
candidates are they are through their course.
Pursuing,
in fact,
pursuing,
their
not yet
course,
complete.
not yet completed, not yet through. Will they be eligible to participate in the recruitment process?
No.
No.
No, there is no confusion. There is no non-application of mind. Everything is crystal clear. But the court has corrected us to a certain extent. Firstly, we need to understand that the notification was originally for the purpose of TET and recruitment, meaning those who are eligible for recruitment, only their TET we will be taking. That was our contention because it is not possible to take millions of TET examinations when my actual target was to do a recruitment. So those who are eligible for recruitment but will be declared ineligible due to not having the TET, only their TET we were arranging. But the court said that no, since TET, even a pursuing candidate can participate in TET. The petitioners has also given the undertaking that we don't want to participate in the recruitment, but we want the TET. Since they were within time, they had come before the court, and those few candidates, 3 or 4 candidates, were allowed. And subsequently, a bunch of matters was heard by my lord, and my lord has dismissed them all as the last date was over. Division bench has also expressed in one appeal a similar view. So reopening the chapter now is not possible.
But the error in respect of, so what they are doing is,
What you say is an error is not an error because court had permitted candidates who intended to take the TET,
yes,
but not the recruitment.
I also,
So, had you come
required-
within time?
if required, now, no, my lord,
sorry.
my humble submission, my kindly appreciates. This this stand of the commission is totally unconstitutional in view of the fact that my lord, Article 16 provides me, my lord, a level playing ground so that I can participate. But my participation cannot be, my lord, taken away. And even if I participate in the TET, I am entitled to the recruitment. When the recruitment will come, I'll be, my lord, qualified.
Intended to participate in the teachers eligibility test, 2025. In terms of the notification published by the West Bengal Central School Service Commission on 9th September 2025. Step. Submission is that the petitioners are pursuing the B.Ed.
Yes, special educators.
For special educators
yes,
course.
recognized by RCI. RCI is
by the RCI.
Yes, Rehabilitation
Next.
Council of India.
The submission is that the commission erred in publishing notification for holding the teachers eligibility test and the recruitment process for special education teachers simultaneously. Step. The eligibility for participating in the recruitment process requires
Page 81. Or if Lashu wants to see the notification, it is at page
There's the minimum qualification
87.
of B.Ed in special education from an RCI approved institute possessing a valid RCI CRR number. Step. As the petitioner for participating in the TET examination, the candidate may be permitted even if he/she is pursuing the B.Ed course. Step. As the petitioners do not have the qualification to participate in the recruitment process, the petitioners only intended to participate in the TET.
And also the
25.
recruitment. Also the recruitment. I also want to participate in it.
Stop. Next. The notification specially discloses the date for commencement of the online application and the last date for submission of the same. Stop. The petitioners allege that they could not file their application within the stipulated time period. Stop. Prayer has been made to permit the petitioners to participate in the TET examination.
And so for modification, I'm praying, kindly comes to my prayer C, my lord.
Prayer has also been made to modify the notification to permit the candidates pursuing the B.Ed course
Prayer
to
E.
participate in the recruitment process. Stop paragraph. Learned advocate representing the commission opposes the prayer of the petitioners. Stop. It has been submitted that the recruitment process was meant only for the candidates who possessed the TET qualification. Stop. The
No, that is not what I'm submitting.
The date that they are holding.
What I had submitted is that since we were proceeding with a recruitment examination, we are conducting TET only for those candidates who have the eligibility to participate in the
That is the error
recruitment.
that I'm saying, my lord.
you will
Date cannot restrict us.
recruitment process was being conducted with the candidates who who intended to take part in the TET?
No.
No.
We were conducting the recruitment and we were holding the TET
And holding the TET
for those who were eligible to participate in the recruitment,
That is
but
the
did not
legality.
have the TET.
That is the illegality, my lord.
being conducted, and TET was the TET was conducted only for those candidates who intended to take part in the recruitment process. Stuff next. It has been submitted that as the petitioner is not qualified to participate in the recruitment process, accordingly, the question of holding TET for them does not arise at all. Stuff. It has been submitted that had the petitioner approached the court within the time period as prescribed in the notification prior to closing of the last date of receiving the applications, comma, then the case of the petitioners for taking the TET could have been considered. Stop. At this stage, when the last date for filing the application is long over, comma, there is hardly any chance to provide relief to the petitioner. Stop. Paragraph. I have heard the submissions made on behalf of both the parties. Stop. The recruitment notification. Now, the notification which the petitioner intends to challenge is dated 9th September 2025. Yeah. On the date of the notification, the petitioners were aware that they were ineligible to participate in the recruitment process, as they are still pursuing B.Ed but have not concluded their course. Stuff. As TET does not require possession of B.Ed qualification, comma, the petitioners would have approached at the opportune moment to ventilate their grievance. Stop. At such belated point of time, the prayer of the petitioners to permit them either to take the teacher's eligibility test or to participate in the recruitment process cannot be permitted. Stop.
One point,
The
lordship kindly notes, my lord, to till date,
prayer
the date.
for a modification of the recruitment notification, subject notification cannot also be allowed despite dates for holding the examination have not been declared by the commission. Post. Service is taken on record.
Deeply obliged.
I am appearing on behalf of the petitioner.
Yes.
I already served a copy of the writ applications upon the all respondents, excepting the learned government pleader.
Accepting the learned government
Yes,
pleader,
by
why?
mistake it was not fine.
Let
Your
that
Lordship,
be made
all the
the
response
office
have
of
been,
the
I have
government
already been
pleader.
received. Your Lordship, kindly adjourn this matter and directed to serve the copy of the upon the learned government pleader.
In the office
and
of the
take this
learned
matter.
government pleader. Released 1st December.
Clerk is coupled to clerk. Lordship, kindly directed to the directed me to serve the copy of the writ application upon the learned government pleader.
Is this direction required?
It has not.
Yes, next. Yes, 70.
70 time for the petitioner.
What
The
is
relates
that?
to that 10 marks for experience that we have on Jawahar Navodaya Vidyalaya. Lordship have already taken to consider. Let it be considered by them, my lord.
How long will this process continue?
They have made first representation.
The results are out. Then how long can this period be stretched?
Some candidates here, Lordship, have already passed out, my lord.
Yes, earlier within time. Now, after the declaration of result, can such direction be passed?
Process has not yet been completed. Only result has been published. And there are
Process has commenced.
yes,
If
comments.
every time orders are passed, then how will the authorities function? They will be troubled with these type of orders, and the entire process will get stalled. One has to draw a line somewhere. What is your submission?
But the first presentation is made in November 2020.
Yes.
They were
After the court's order.
They're not even fence sitters. They have crossed the fence and sat.
After the order is passed.
They are
Why will this be
they are
considered?
similarly situated like the other. Only because
There may be several similarly situated candidates on the day just prior to the publication of the final merit list.
Yes.
How long will the court permit? There has to be a limit. The court did permit.
Let them
But
consider. They will consider whether they are, if they are eligible, they will give it a number. Otherwise, not.
Take it that you are in the otherwise lot. Please come. The marks, the results that have been declared, does it contain the prior teaching experience marks? No. So not yet done. The petitioner is a Navodaya teacher. The petitioner claims to be teaching what?
I have been told that perhaps they have published the result after awarding marks for the prior teaching experience.
No.
In the morning.
The interview list was published. The interview list was published without verification. Verification will be done later, calculating the written score, academic score, and prior teaching experience.
Are separate columns mentioned? See, this is
details they have not published. They have given the interview list.
Overall number has been given.
And instruction with prior teaching experience, because that is why the cutoff and no fresh candidate has gone. That is why, my lord, so many
matters are coming. The petitioner claims to be teaching in the.
My lord, separate experience has been given by.
Is given. Yes. No, you do not have to show. You tell me, I take it. I will not deny whatever is there. The petitioner claims to be a teacher in the Jawahar Navodaya Vidyalaya. She claims, she participated in the second RLST and claims marks on account of prior teaching experience.
Three petitioners are there.
Petitioners. It appears that the commission has already published the interview list containing marks of the eligible candidates, including the marks obtained by them on account of their prior teaching experience. The petitioners rely on the order passed by the court on 23rd September 2025 in WPA 22321 of 2025. Shisha Ghosh versus State of West Bengal and others. Page 37. The prayer of the petitioner for considering her experience of teaching in the Jawahar Navodaya Vidyalaya cannot be allowed in view of the fact that the interview list has already been published by the commission. Had the petitioner approached this court at an earlier stage prior to the preparation and publication of the interview list, the prayer of the petitioner could have been taken for consideration.
Okay, file
Stop.
করছি।
At this stage, if the petitioner's prayer is allowed, comma, then the same may the
we
same
filed it-
may hamper the regular process of recruitment, which is being conducted in terms of the order passed by the Honorable Supreme Court. Next. In view of the above,
we approached it on 10th November.
writ petition fails and is hereby dismissed.
We approached it on 10th November, my lord, before publication of the result, my lord. Kindly
Doesn't
consider
matter,
this
it
aspect.
cannot be helped.
My lord, on
Yes.
10th November, my lord, we approached, my lord.
Immediately you couldn't obtain an order. You could have mentioned, I have accepted all matters. You took no steps. What can be done? Yes, 71.
71, my lord. Same issue as in the morning, my lord, your lordship. The only difference is, my lord, firstly, this petition was filed before even the result was published, let alone, my lord, the interview list. My lord, only thing, if your lordship kindly counsel only one page 22. Here, my lord, the sanctioning memo has already also been given that the post is sanctioned. My lord, all this thing has been done by the commission. Now, my lord, they cannot say they will, and verification is still not yet started. So the question of the rule says
22 is by the school.
yes, giving the memo, my lord, mentioning the memo of date of sanction.
And the writ petition has been filed in your lordship court on the 11th.
And my lord, another thing, my lord,
Result
the
is
rule says I can place these rules also. When can the interview list be published? My lord, kindly comes to the rules. Rule 11.8, my lord, I am going to place, my lord.
Provisional part-timer. In the morning, when was the matter fixed?
My lord.
When was the earlier matter fixed? 2nd of December.
No, that relates to, my lord, private school. This is a government school. In the morning, item
This
number.
is a government school?
Yes, my lord. My lord, only wants to rule 11.8, page 35.
Page 35.
My lord, I am reading 11 sub Roman 8.
Yes.
Central Commission shall prepare and publish in its website a preliminary list with details of the candidates to be called for interview, subject to verification of credentials. I stop here for a moment, my lord. Verification has not yet been done. So whatever has been published, it's tentative. Since verification has not been done, my lord, this can be, my lord, given. My lord, the commission shall take a decision pursuant to page
Please
22.
come. The petitioner claims to be teaching in a government school in a sanctioned post since 2018. Stop. It's a he or a she?
My lord, she.
Acha, she participated in the second SLST. Stop. She seeks marks on account of previous teaching experience. Prior teaching experience. Stop. The certificate issued by the school in favor of the petitioner on 6th December 2025, annexed at page 22 of the writ petition, is relied upon. Stop. Paragraph. Without entering into the merit of the said certificate, the instant writ petition stands disposed of by directing the commission to take into consideration page 22 of the writ petition. Stop. If the petitioner can be treated to have prior teaching experience, then necessary allotment of marks shall be provided.
Not only two things. Your lordship has been
Decision
pleased to-
shall be taken in the matter at the earliest.
Your lordship has been pleased to dispose it. Please, two things. First is the certificate is dated 6th of November.
Obviously.
6th of, if someone is working, he had the option, he has not annexed the application form.
He could
in
not
the writ
have.
petition. In the application form, he could have. In the application form, he could have indicated.
He
the
could
6th
not
of
have.
the post result document or just prior to publication of written results. 7th was the date. And 10th, is the interview list. Now today, my lord, by citing rules, my lord, kindly do not open. This is, my lord, with greatest of respect, my lord,
This one there, it's mentioned sanctioned. In the morning,
my lord,
there
is
was
the
no mention
sanction.
about sanction.
Who is mentioning?
Check up. If it is not, it's not.
My
This is
lord,
what?
kindly records our reservations, my lord. Kindly, my lord, that we are, my lord, opposing this, my lord. Kindly.
The prayer of the petitioner has been opposed by the learned advocate representing the commission. Stop. It has been submitted that petitioner obtained the certificate in support of his prior teaching experience only from the experience from the school only on 6th November 2025. ঠিক আছে? প্যারাগ্রাফ দিয়ে লিখুন যে the certificate relied upon by the petitioner mentions about a sanctioned post where the petitioner is teaching since 2018. ঠিক আছে? The commission is the ultimate authority to take a call on the said certificate. বলে পরে যেটা দিয়েছিলাম বলে dispose.
Only one other indulgence, my lord, and item number 4, I have just had a word with him. Item number 4, your lordship has been pleased to keep it on second. Instead of second, can it be on third? Just this much, my lord.
What is so special on second?
Second, my lord, I'll be in some difficulty.
সকালবেলা কত নম্বর? 4 নম্বর আইটেম আপনি নিয়েছেন? ও 2 তারিখের জায়গায় 3 তারিখ করে দেবেন।
একটু দাঁড়ান।
Great.
মারাটা ইন মাই
পাঠিয়ে দিয়েছিলেন, আমার কাছে পাঠিয়ে দিয়েছেন? আচ্ছা ঠিক আছে, একটু বৈশালী বা গৌরব দুজনকে
also Malat, I have annexed the certificate Malat of the Malat kindly the earlier matter Malat I have
earlier it could have been allowed.
Malat is also Malat I approach
Come earlier.
Malat same time Malat by learned friend Malat approach on 11th I approach on 10th my lord. Malat let it be Malat. Malat let it be Malat kindly I have also annexed the certificate of 6th November Malat kindly see Malat page 28. My lord kindly Malat.
It is
Malat kindly my lord.
delayed approach.
Malat kindly my lord.
Vidyalaya issue stood decided by the court on 23rd of September.
Malat
Here it is not so. Here it is, it may be, it may not be. But Navodaya is yes. And the commission has admitted that.
Malat that certificate I have annexed my unit petition my lord. Navodaya certificate.
This is what the court is saying, that you should have come earlier. You could have got mandatory order.
My lord,
At this stage, it cannot be
my
done.
lord, kindly, my lord, if we one matter,
Rush
your
to
lordship.
the appeal court,
My
get
lord,
it done.
My lord, kindly, my lord, let.
No, sorry. Next. If I open gates for you, there will be rush over here. Why I am closing it? The commission has allowed Navodaya. You've come late.
The entire Navodaya will be now vacant. All are coming to.
No, sir. Who's going to teach in these schools? Anyway, less said the better. Yes.
Item number 72 is regarding 3% additional increment, my lord. This is your lordship's earlier order. The lordship has issued.
When did you join the upgraded school?
Joined the upgraded school in the year 2006, your lordship.
Your initial joining?
Initial joining in the year 1987, my lord. Now I am retired.
In 2023,
yes,
the memo came, right? And show me your joining, 2006.
The school was upgraded in 2006, my lord. That is at page 29. And
When did you join?
Yes, my lord. My lord, I joined in 2001. That is at
No, but
page 27.
upon being upgraded, you started teaching in the upgraded course, 2006. Your appointment must be there in the upgraded portion also. Where is that?
Yes, my lord. My lord is seeking the approval in the upgraded portion.
Yes.
That is not annexed here, my lord. If your lordship kindly allow me to come tomorrow, I will place it before your lordship.
Because that is exactly your case.
Yes, my lord. Yes, my lord.
That you started working in the upgraded section.
দেখো তো-
Show me that the upgraded section you were permitted to work.
Yes, my lord. That is not I perhaps. My lord, in the page 27,
Yes.
Kamal Kumar Panda, headmaster, date from which approved, that is 19th October 2001. But subsequently in the year 2006, the institution was upgraded.
And you are teaching in that upgraded section.
Yes,
Where
madam.
from will
That-
the court get to
But
know
I
that?
was enjoying at that point of time the headmaster. Yes, madam.
This is in 2002, page 27.
Yes, madam.
There must be some fixation thereafter.
Only, my lord, in the page 33, the Kamal Kumar Panda HM designation that was format for provisional pay fixation 2019 is there, my lord. Otherwise, there is.
Where, which one? This is
Let's
the
take-
IOMS.
Page 33.
Enhancement of pay, approval of appointment, non-teaching staff. Kamal Kumar Panda. Designation. Where is it mentioned in the
In the
upgraded section?
my lord, in the year 2000, my lord, it is the option of 2019.
Yes.
And the school was upgraded in the year 2006, my lord.
Right.
So therefore, my lord, HL, automatically it was upgraded section. He was enjoying the position as an HM. My lord, though, my lord, I have not the approval with me, but there is, my lord, it is mentioned.
Please come.
My lord, kindly make it not today.
Higher scale of pay. Now, petitioner praise 3% increment on account of his teaching in the upgraded section of this school. Stop. Learned advocate for the petitioner is directed to file supplementary affidavit disclosing documents to show that he worked in the upgraded section of this school.
May I submit one thing?
Where is the proof to show that he worked in the upgraded section?
Page 29. My
89.
Yes, my approval, page 27. This is my approval as headmaster.
Yes.
This school has been upgraded.
But then you had to teach in that upgraded section.
Not teach, taking responsibility as headmaster.
All right, you take a responsibility. Where is that? Where is that you took responsibility of that upgraded section?
I am a headmaster, otherwise nobody had. I am a headmaster.
In the other matters, there are documents to show that he was directed to take charge of that upgraded.
Automatically, there is no other headmaster in after upgradation.
I do not know.
School has been upgraded.
I do not.
Headmaster one. So, my lord, the headmaster has taken charge of the automatically and taken responsibility.
And this notification is of the year 2010. Upgradation was given in 2006. Did you ever get the benefit?
Yes.
Never.
This notification, school
Did
has
you,
been upgraded.
was your pay hiked, thereafter reduced?
No. 2009, that is the ROPA with effect from 1st March 1/1/2006. That is why I am entitled for the benefit of ROPA 2009.
Yes, but the upgraded portion, right? Was your did you ever get any increment on account of upgradation of the school?
No, that is why, my lord, I moved a writ petitions, my lord, taking 3% increment. That has been settled by this honorable court. They have my averment in the writ petition that the
Yes, averments are there, but documents are not very.
no documents, my lord. I have
in other matters you had documents.
Maybe some DI, my lord, approved the pay scale as headmaster. Some DI automatically I have taken charge, my lord, as headmaster in higher secondary also. And no other headmaster. Headmaster or headmistress is alone in secondary and higher secondary. There is no requirement. That is why page 33.
Where is your application?
Page 30. Once, my lord, page 33. You will also kindly see.
33.
33.
No, 33 is separate. That is the IOMS. Where is?
Yes, automatically this also, my lord, the Kamal Kumar Panda, he is also headmaster of that school. after upgraded 2020. Other my lord assistant teachers, their approval has been accorded by the DI.
Where is your application? Seeking higher scale of
No,
pay?
that is the my lord, your lordship.
Oh, তাহলে তো ঠিকই
ওটা
আছে।
কোথায় কোথায় order টা কই?
হুম।
Orderটা judge.
Order
That
is here.
lordship my lord, I have handed over the order passed by your office.
তাহলে the petitioner seeks additional increment on account of his joining
জানি বাবা।
the upgraded school.
এইটা কবে স্যার?
On account of his
লাগবে না।
performing duty.
না না না, এই যে
In the upgraded school.
আলাদা করে সেপারেট অ্যাপ্রুভাল দরকার লাগে না, করে না কেউ, করলে করবে, যে কেউ করে কেউ করে না।
In terms of the memorandum. এই অর্ডারটা তাহলে করে দেবেন, এখানে শুধু জয়নিংটা কেটে পারফর্মিং ডিউটি। অলরাইট ডিসপোজড।
The first paragraph, my lord, I have subject to correction, my lord, I have corrected, my lord, the year. That is why, my lord, I have mentioned, my lord, for correction, the year has been, my lord, wrongly typographical errors. You also can see the first paragraph. That can be removed, my lord.
I have removed it.
I get full. এটাও কি করে?
Similar, by retired employee, year 2014 it was upgraded.
এটা কি আপডেটেড?
Upgraded. আমি করেছি, আমি রিটায়ার্ড।
না না, সেও
Yes.
This is also same. But the 73, ওই একই order. ওই একই সেম লিবার্টি দিচ্ছে।
ওইটা করে দেবেন, জয়নিং এর জায়গায় পারফর্মিং ডিউটি ইন দি আপগ্রেডেড স্কুল।
এটা তো আবার করেছি তো।
Yes.
করেছি।
74.
Same as I said.
74 malata similar malata.
Navodaya teacher?
Malata.
So sad.
Kindly malata kindly.
I do not know. Can any kindness be shown to them? Up to you. The court is not willing.
We are overburdened with kindness.
I do not know.
Similar type of matter or lots of have already fixed on 28th also.
You want it on 28th? Released on 28th. Sharadin released on 28th. In the meantime, you see if Navodayas can be accommodated, then I can allow these.
Let's see if it's not great.
In the meantime, they will lose a chance.
Better they will let them reconsider.
Verification, hearing, all these.
You have not verified credentials of any. Yes. It is a continuous process.
All these things, and the resources is also limited. 30 people working together.
That is up to you. It is your commission.
It is enough for that I am led by Mr. Hotel.
Yes, yes.
Yes.
74.
74, what to do? Mr. Bhattacharya, Navodaya. Will you come back tomorrow? Take some instruction if anything can be done for Navodaya.
I'm being very honest with you. On instructions, I am not submitting this, but they are not minded to do it.
All right.
Let us be very honest, your lordship may switch it off, take it, from us. They are not minded. They are not minded.
They are not minded at this stage because there are courts ordered in respect of others.
No,
Shisha Ghosh. That was the submission.
We have only taken.
Taken
We have not
means?
taken any decision. We have taken the certificates and we are, it's the process of passing on.
No, but then I can remember before the division bench submission.
Submission, one aspect, since my lord was, I could see this side.
Yes, yes.
Is today allowed. then perhaps
Many will come.
because
Not only this, why I'm making this observation is because there was a submission before the division bench that the central government schools and everything, they will be considered. And wherein Navodaya came in. You have Justice Sen's order. Justice Sen's order. Will you take them also into consideration? Because if it is Navodaya, same benefit can pass on.
Yes.
these are all related reports, high prerogative.
Absolutely. I take it.
And whatever today, let us
See, it is
fill out
today.
instruction. If today they decide to give it to everyone, then these persons will also flow in. Irrespective, because we are commission, kindly will not bear with us. We have to, my lord has to handle 100 matters a day. It is impossible for your lordship to recall where your lordship is, unless it's a very elaborate thing. Similarly, my lord, the commission is also not very aware who has come and who has not come to court and whose petition got dismissed. Unless specifically targeted or informed of something of that. If today, assuming the commission.
Do I keep it pending to awaiting order of Shisha? Because you say.
Shisha, my lord, I had the occasion to appear, my lord.
Has any decision? What about her marks?
Shisha, along with 4 others, pursuant to order of the division bench,
Yes.
were called by the commission. All the documents were taken that whether the post is sanctioned. The only thing they said, if the post is sanctioned, we will give you marks. In one of the matter, Navodaya has given, your lordship has also disposed it of that the post is sanctioned. They were also of the, according to instruction, my lord, I am submitting that if the post is sanctioned, we will award marks.
No, there is an issue. In Shisha, what I find from the documents, that she was employed only for a brief period from July to April 20. So, each case has to be tested on its own facts.
True, but then are you all considering?
Duration is also an issue.
Duration is separate. Duration is separate.
And duration match, and if we allow Navodaya, then all Navodaya is perhaps.
Yes, right.
Assuming Navodaya is allowed and a person does not have the basic.
He won't. He goes.
There is
another. Will not be allowed.
No.
Assuming Navodaya is allowed.
This is the reason I am mentioning about Navodaya. I am not taking anybody's name. The issue is Navodaya schools. Are you all allowing or not allowing?
You just offhand inform your lordship that we are minded to give it or not give it.
What happened? Was Shisha given 10 marks, 2 marks?
What is the main problem? All these Navodaya or central schools, the website I can show here, my lord, here and now, has been so designed. The first column was, are you working in a state government school?
That I follow, you could not.
Nobody under central school or Navodaya could even fill up the form. That is why Shiksha Ghosh came at the very beginning saying that, see, and the court, my lord, if your lordship sees Shiksha Ghosh order, courts observe that you have designed in such a manner, nobody can fill up. So the question of everybody will be given, commission cannot say so, because there is no record with the commission that
I give it to everyone. Again, another expedition is going to come from his instance that this has been done partially. Yes, we are at loggerheads. We are before your lordship's court, and we are also.
No. You have to design your module in such a manner that your idea is clear.
Not coming in the month of May.
Shiksha Ghosh came in the month of May, matter taken up in September.
So that is that is not my fault. If today Shiksha Ghosh has filed a writ petition and it was kept pending, for 3 months, and it was only moved during vacation, that is not my fault.
And my lord, against Shiksha Ghosh's order, no appeal was preferred. They accepted the order.
And this is again going to open a floodgate because.
My lord, the question is not the duration. A candidate might have 6 months experience, he might not get any marks. The question is whether you are allowing now.
The principle is how
Principle.
much marks is
One may
different.
get 1 mark, one may get 2 mark, one may get 0 mark. That is not the issue. And nobody has come before your lordship saying that I am entitled to 2 mark. It's whether I am entitled to marks.
Sure. Continuous service and substantive post will allow on instruction. Your lordship will record it. Continuous service has to be there and substantive post has to be.
If I can recollect, were you there or Mr. Nag was there? I do not recollect. Mr. Kolan Bandyopadhyay was there and he permitted filing of application 7th or 8th or 10th was the date of the hearing. Remember? And submission was, if it is sanctioned, Navodaya central government, we will allow.
Yes, that is also my submission. I am not saying something different. Continuous service has to be.
That is the next step. Do you get it?
Today, kindly pardons me, who are coming to your lordship's court, who admittedly has kept that thing blank or has
Could not have.
misunderstood it or has
No.
not given a representation?
No.
There was no column according to this.
It could not have been.
Despite that, on instructions again, Milord, I am told more than 2,000 plus applications have been received.
Yes. How could they mention that they were in the?
That I of course got to take it.
It cannot be.
They kindly do not pass any order at the instance of fence sitters who are coming to your lordship court after Kisha's order passed in September or October, after publication of the interview list, tentative, whatever, a list has been published.
That is the order I passed in the earlier matter. Right?
Keep that order.
But then, if on principle you all are accepting,
the principal part, if it is allowed, it is allowed. Then what we have learned, we also debate.
My lord, with deepest of respect, when a candidate has not been allowed to fill up the application form and they are later on taking a decision that this batch of persons in a central school will be allowed, delay doesn't come, my lord, at all.
He did not go to Mr. Dasgupta. Had he gone to Mr. Dasgupta, then the writ petition would have been filed.
My lord, it's not on that. There are many matters. It's not about going to whom.
Difficulty is that today, with the 6th November certificate, someone is approaching your lordship's court on 17th of November, saying 6th November I have been certified to be a teacher in a substantive
You
post.
have not
Who is
yet.
certified?
You have not
The
yet
school.
started verification.
that certificate was not required. If your module had been prepared in such a manner that they
Let us
could have
assume-
put in
Let
the.
us assume for a moment, that the module was wrong. Let us assume, what were they doing all this time?
And
where was the module issue all this time? They ventured to your lordship's court. The rules were published on the 10th of May 2025, if I am not mistaken.
30th of 29th.
29th of May. Within 2 days, at least 10 writ petitions were filed, in your lordship's court, in this court, in courtroom number 18. Within 2 days. And writ petitions were filed within days.
Please
that
come.
it was filed.
Please come.
So if they were so vigilant, why are they not vigilant today?
আগেরটা petitioner. How many are over here? How many are here? How many are here? 8.
Yes,
The
74.
petitioners claim themselves to be teachers of Jawahar Navodaya Vidyalaya. Stop. They participated in the SLST, second SLST, and seek marks on account of prior teaching experience. Stop. The learned advocate for the commission submits that the commission, on principle, has taken a decision to take into consideration the prior teaching experience of teachers of the Jawahar Navodaya Vidyalayas, provided their service is continuous against a substantive post. Stop. Next. As there was no occasion to disclose prior teaching experience of teachers of the Navodaya school. Accordingly, the commission is directed to take a decision on the decision relying on the certificates annexed at pages. Where are your certificates? Give the page numbers.
46 to 85.
No. Oh, how many teachers are there? Not more than 8.
Various certificates.
8 pages.
Yes, my lord, it says 46 to my lord 85. 46 to 85.
How many days did you teach? 46.
July to April.
Which one are you referring to?
Matlab all or matlab with different times.
Which item number?
This is 74.
74 এর ফাইলটা চলে গেছে। দেখি একটু
46 to 85, my lord.
46. From done. July 23 till April 24. Not even a year.
Yes, madam.
এটা কি? এটা হচ্ছে
No, next page is there. Then next page is there.
next when?
Next page is my lord
48 kindly says 47, 48.
June 21 to my lord August 21.
2 months.
Yes, next is also my lord August 18 to April 19.
Not even a year. Where is the continuous service?
Malat, if we
2 marks for each year.
if we calculate malat all those certificates, malat it will be the continuous service.
2 marks for each year. Service has to be continuous.
Yes, madam.
Where is the continuity in service?
They are continuously servicing, malat, their service was renewed from time to time, malat. Sometimes 6 months, sometimes 8 months, sometimes 9 months.
Sometimes 6 and 8. Are they back to back? No.
Yes, my lord. Kindly consider various certificates as there, my lord.
Various certificates, show me one that it is continuous. There has been break in service. You cannot say.
No, my lord, kindly see my lord, page 49. Page
Yes,
49
page
is
49.
25th June to 30th, my lord, 24th to 30th April 2025.
Yes.
11 months. Next, my lord, next page, my lord, kindly see.
Where is 1 year complete service?
1 year complete. No, 1 year.
2 marks for each year's complete service. Not a single one.
My lord, they consider 10 months as a year because during the vacation, my lord, they
10 marks is for 5 years. 2 marks, 1 year.
no. 10 months, 10 months they considered as 1 year because during the vacation they did not allow any person.
Then how can it be said?
In every school, their certificate is there. For the vacation, they do not issue any certificate for the vacation period.
And that is up to the school. I do not see that 1 year continuous service
In
is
every
there.
case is there, in every
What can
case.
be done? It cannot be done.
Let it be considered. If we fail to, we shall prepare a chart to that effect, considering those certificates. For one person, so many certificates. Kindly see.
And TGTs, are they in sanctioned posts?
Yes, my lord.
Contractual teaching job is all right, but then I do not think TGTs are. I'm not very sure. Where is the sanction? Show me. Anything to show that it is a sanctioned post? How can the authority take a decision in the absence of proper papers? 7 till. See, you are saying that the vacation period is not taken, cannot be given the letter. Page 55. From July 17 till April 18, the Christmas vacation must be there and it is recorded. And how do you say? Na, page কি বলে 70 তে যে অর্ডার ছিল সেটা থাকবে, same order will go down in 74. I'm sorry, I cannot help. Dismissed. Same order in 74. Please give appearances. I can't help.
Let me come with the chart, my lord.
No, nothing. 75,
Let me
please
come
call.
with the chart, my lord. Let it be on 28th, my lord.
75.
That is my petition.
Yes, please. What is it?
That teachers of that private institution, they are seeking that benefit of 10 marks. Basically, my argument is that NCT Act does not
I fix it on the 28th. List on 28th.
along with other matters.
Along with other.
What December?
3rd December.
Let us see if something comes up on the 26th and 28th, 24th and 26th before the Supreme Court. If anything comes.
They ought to be skipping this pattern on 28.
28th.
76 same as item number 3 and 71 of part-time teacher minor sanctioned government sponsor.
The petitioners claim to be part-time teachers of
Well, this private teachers,
no 76 part-time teachers,
Part-time teacher.
private schools.
No, government sponsor.
Acha, private teachers are part-time teachers of government sponsored schools. ঠিক আছে? They seek marks on account of prior teaching experience in second SLST. Stuff. In the morning, matter was fixed on the 2nd, 3rd.
My lord, your lordship has disposed it of.
Oh, it has been disposed of. Consideration.
Item 71, only difference is page number will not be there since there are several.
State is submitting the visa on sanction.
71
I
কি
have
বললাম
the document of the state itself of West Bengal Council of Higher Secondary Education.
All right, same as 71.
My lord, only that page number will not.
Tally. Page number of the certificates.
No, my lord, page number. Your lordship, there was a single petitioner.
Huh?
In terms of that, only that portion need to be corrected. They will not be considered.
All right. Same as 71.
Will your lordship record an order in my matter also? In 75, will your lordship record an order?
75. Acha, ki y'all are contractual teachers.
Teacher in a private school,
Contractual. 75 record করে দিন তো. The petitioners claim to be teachers. 75.
are employed with private school.
Petitioners are contractual teachers in private schools. They seek.
All are permanent, not contractual. We are employed with private school.
Employed with private schools. এই উপরে যেখানে বললেন না পার্ট টাইম না কন্ট্রাকচুয়াল ওটাকে কেটে দিন. Teachers of private schools. They seek marks on account of previous teaching experience in second SLST. ঠিক আছে? Released on 28th.
That's
আচ্ছা 76 তো হয়ে গেল 77 77
Lordship will take up today, my lord, since
oh it's already
uh,
4:30
tomorrow, my lord, I am coming.